And remaining objection is in office having posted amount deposited address.
ಇವತ್ತು ಮೇಡಮ್ ಎರಡು ತೆಗೆದ್ರೆ
ಎವ್ರಿ ಕೇಸ್ ಕೇಳುತ್ತಾ ಎವ್ರಿ ಕೇಸ್ ಅಲ್ಲ ನಿನ್ನೆ ನಂಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ ಹತ್ತರಿಗೆ ಬಿಟ್ಟು ಸಿಕ್ಕಾಪಟ್ಟೆ ಸ್ಲೋ ಇದೆ ಮಧ್ಯಾಹ್ನ ಇದು ಆಮೇಲೆ ಅವಾಗ ಸ್ಲೀಪ್ ಮೋಡ್ ಹೋಗ್ಬಿಡುತ್ತೆ ಎವ್ರಿ ಒನ್ ಅವರ್ ಸ್ಲೀಪ್ ಮೋಡ್ ಹೋಗ್ಬಿಡುತ್ತೆ ನಿನ್ನೆ
ಇದು ಒಂದೊಂದ್ಸರಿ ಹಂಗೆ ಆಫ್ ಆಗಿ ಹಂಗೆ ಆನ್ ಆಗುತ್ತೆ ಸರ್ ಫುಲ್ ಹೊರಟೋಗ್ಬಿಡುತ್ತೆ ಹಂಗೆ ಆನ್ ಆಗುತ್ತೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಮೇಡಮ್ ಹೇಳಿ SMC ಅಂತ ಬಂದಿದೆ ಮಾತಾಡೋದಂದ್ರೆ ನಾನು ರವಿ ಕೇಂದ್ರಾಜ್
ನೀನ್ ಏನಾಗ್ತದೆ
ಕೊಟ್ರಿ ಆಯ್ತು ಇಲ್ಲಿ ಮಡಿಕೊಂಡಿದ್ದೀನಿ ಎರಡು ತೆಗೆದಿದ್ದೀರಲ್ಲ
ಸೇಮ್ ಡೇಟ್ ನಿನ್ನೆ 140 ಡೇಟ್ ಆಯ್ತಲ್ಲ
ಸರ್ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ ಕೇಳಿದ್ರೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅನಿತ ಎಷ್ಟು ಇಷ್ಟ ಆದ್ರೆ ಏನಿಲ್ಲ ರೀಚ್ ಆಗಿದ್ರೆ ಅರ್ಜೆಂಟ್ ಮಾಡೋದು ಅಷ್ಟೇ ಹೆಸರೇನು ಯಾರನ್ನ ಬರೆಯಕ್ ಕಳಿಸ್ತಾರಂತ
ಗೊತ್ತಿಲ್ಲ ನೀವು ಹೇಳಿ ಸರ್ ಕರ್ಸಿ ಅಂತ ಹೇಳಿ ತುಂಬಾ ಬಿಸಿ ಇದೆ ಅಂತ ಹೇಳಿ ಎಷ್ಟೇ ಇದ್ರಲ್ಲಿ ತೆಗಿ ಜಡ್ಜ್ಮೆಂಟ್ ಡೌನ್ಲೋಡ್ ಮಾಡೋಣ ಕಾರಣ SSC ಆನ್ಲೈನ್ ಅಲ್ಲ
My lord, submission in this case.
No submissions, all memos to the court officer, call the list. Huh? MFA memos I'll not take.
RPFs.
Huh?
RPFs.
Take, any fresh matters, memos are not required because the matters will come. No memos for the fresh matters. Don't take any memos for the fresh matters. Yes,
My lord, there is a urgency. That's why
in
I'm
what?
saying urgency in this case, appellant is the husband. Wife met with accident. Entire amount has been granted in favor of father and mother. Now appellant is before.
MFA of which year? MFA of which year?
This year, please.
Uh,
Then the husband is termed as.
No, don't tell me all that. Whether the matter is listed till today or not.
No, not.
Fresh matter will come, automatically it will come. As per the directions of the Chief Justice, auto list. The moment your case is numbered, it will come in the list. For that, I will not take any of the memos. You please, office objections you comply with, the matter will come.
But what happened in this case?
No, nothing, nothing. Yes, please come.
Page-wise adjournments, if any.
Yes.
List number 1, page number 1, serial number 4, page number 2, 5 to 13, page number 3, 14 to 24, page 4, 25 to 31, page 5, 32 to 38.
My lord, serial number 33, my lords, appear for the petitioner, my lords, seek a week's accommodation. The other side is not 33, my lords. Other side is not.
ಇನ್ನೊಬ್ಬ ತಿಕ್ಲ ಅಡ್ವೊಕೇಟ್ ಕೇಳಿದ್ದೆ ಕ್ವಶನ್.
Yes,
Much obliged, my lords.
yes.
Page number 6, 39 to 44, page 7, 45 to 49, page 8.
Serial number 47. I am
40?
for the 47.
Huh.
For the respondent,
Uh,
and I will file the objections today in the registry.
You have?
Objection is ready, my lord. I will file it in the.
Objection for what? MFA? Why objection in MFA?
My lord, I am a proxy counsel, the regular counsel asked me to do so. That's why.
Even you should choose some other way to, excuse for asking adjournment. In MFA, what objections you will file?
I have given.
For R1 or for R2? Which
Have you informed the counsel for the petition appellant? Then I think I don't have to tell you what to do. Wait, yes.
Page number 8, serial number 50, list number 2,
Yes,
list number.
List number 2, serial number 24 and 25. It has to be
I think
connected.
he's calling by page wise.
Yes.
He missed the page number.
Page number 10, 36 to 38.
Oh, these are all orders matters.
Yes, madam.
Serial number 36, my lord.
Huh?
Serial number
You're saying
36.
about 25.
24 and 25.
Huh?
This is connected with the company appeal, my lord, 6814 of 25.
No, but this memo is there for dispensation and
That
all.
can be done, but it can be called along with 6814 of 25. I'll make a submission when it reaches.
When the matter reaches, yes.
36, my lord.
Huh?
Today I have filed extension of time, my lord, for depositing the amount. And
36.
connect 36, second list.
N. Uday Kumar.
Hmm.
Today I have filed IA for extension of
MFA
time.
of 2024, when is the order passed?
Order passed 3/9/2025, my lord.
You please, those kind of mentions I'll not accept it at this point.
Connected matter also,
Let it come. When the matter is called, please be there. Yes, next.
Page number 11, 39 to 45, page 12, 46 to 51, page 13, 52 to 57, page 14, 58 to 61, page 15, 62 to 65, list number 3, page number 1.
Serial number 3, my lord.
3 to 5.
Serial number 3, my lord. Appealing for the respondent, my lord. In this, the parties have arriving for settlement, my lord. Seek and short adjournment, my lord. I have informed the other side, my lord.
No, when parties are seeking adjournment, no need
No,
to.
my lord, in the matter, it gets for
2024
settlement,
matter,
my lord.
why we have to adjourn?
Get
I think I
settlement.
remember last time I said only, I'll not grant further adjournments.
My lord, in this case, the parties have been arising for settlement, my lord, in FC court.
From when? They can arrive at the settlement before the mediation.
Next date is
In
on
the-
9,
in the MC.
9 of this month, my lord. Any short accommodation can be given, my lord. Seniors out of
I
station.
don't
my lord.
understand what is this,
Seniors out of
what
station.
happiness it gives to keep the matters pending here.
Short
This is
accommodation.
matter at the request of learned counsel for the respondent on on 21st, no further adjournments will be granted. It is submitted that the same is informed to the council for the petitioner. Yes, next.
List number 4, page number 1, serial number 1 and 2.
Yes, the other need not call. It's a 230 matter. Yes.
List number 1, serial number 1.
One matter for admission.
Huh?
Admission.
No, I will not take any memos for the fresh matters because they are, once you number it, they are getting listed.
Serial
Yes.
number 1, Vijay Kumar.
I am for respondent.
Of the appellant, my lord. Kindly 1 week time. grant.
What 1 week time? From the last
My
2-3 occasions, you don't
my
even
senior
appear.
brother is died, my lord. My senior brother is died.
List this matter after 2 weeks on 27th of November. Yes. Delete from the caption part. Yes, 2.
Farades, serial number 2.
I have filed the cost title as per the award, please.
Hmm.
Facts of the case, 2 vehicles are involved in this case.
Stay petition is there.
Please,
Hmm.
I'll deposit the 50%, please. 164A, so 164, charge sheet against the claimant, please, madam. FIR charge, everything against the claimant.
The appellant is, the land council appearing for the appellant submission. The charge sheet is filed against the claimant or deceased?
Claimant first respondent. Claimant here, first respondent here.
Against the claimant. And when the charge sheet is filed against the claimant, is not entitled for any compensation under section 164A.
Please, 164, please. Earlier
Under
160,
section
now
160
160.
164. It is submitted that all these aspects were not considered by the court. Considering the same, they shall be stayed. It is submitted that already 50% of the amount is deposited.
No, not deposit, ಮಾಡ್ತೀವಿ sir. No, statutory deposit made, 50% will be made
They shall
including.
be stay of all further proceedings on the condition that he shall deposit 50% of the amount within 4 weeks. Notice to the respondent.
Please.
Serial number 3, V. Chandrasekharaya.
Appear for appellant, my lord. Pressed to accept submission, my lord. Appellant petition number 1 is died, my lord. Appellant number 1 to 4 already on record, my lord. Submission is on,
1 minute, let me look at the cost item.
please.
Hmm. Kumar,
Kumar is dead, my lord.
petitioner 1 by so and so.
1 to 4 is already,
Died.
after the disposal of the MACT. Yes, award is apportioned to him also.
What is the procedure in that case? You should file an application seeking to file the appeal as the deceased was no more. That's not the procedure.
Yes, my lord.
Then?
For want of death certificate, date of death is not available. Acceptance, it comes, my lord.
Not
Please,
that.
please
No,
accept the submission, then I will proceed further, my lord. Application and
No, you are not a party to the proceedings,
earlier,
trial court proceedings. No, straight away you will come on record and you ask the court to accept the note. I don't think that's a procedure. That's what I'm saying. I don't know what is the procedure here.
procedure application is to be filed, my lord.
I'm seeking application to pursue this appeal.
Yes, ma'am.
As in the light of so and so.
Yes, my lord.
But this, how can I accept the note?
Only there's a posted for acceptance, my lord.
Yes, Mr. Ravi Sampriti. That's how it is.
Yes, my lord. I will press time for filing.
For example,
application.
during the pendency of the appeal, the
Application has to be
claimant
filed,
is
madam.
no more. Now the LRs want to file this petition. Now what he says is, straight away he'll come before the court, cost title, 1 dead, we are the LRs, and accept the cost title.
No,
No,
they
no.
have to file an application to implead themselves as parties in the appeal.
LR application.
It's not because it's not question of implead, seeking you should file an application saying that seeking to pursue this, seeking for leave of the court to pursue this appeal because the deceased is no more.
Order 22 is.
Yes, all 22 rule 3.
The matter is placed before this court for acceptance of the note below cost title. Since claimant number 1, deceased, is no more after passing of the judgment. The petitioner shall come up with appropriate application seeking leave of the court to prosecute this appeal. And in this manner, the court cannot accept the cost title. Yes,
Press for time to comply the
2 weeks, right?
3 weeks, my lord, because
3 weeks, take your own time.
please.
Yes.
Serial number 4, Sushmita.
My lord, in this case, I appear for the appellant, my lord.
Hmm.
Kindly, a notice may be issued to the insurance company, my lord.
Which is insurance company?
National Insurance Company, my lord.
Mr. Janardhan Reddy is directed to take notice on behalf of the insurance company. Respondent number 2?
Who is National Insurance?
Huh? The respondent number 1?
I'll kindly file memo for dispensation, my lord, in the counter.
Again, it has to come for that.
Today itself, I'll file it, my lord, in the course of the day.
Come, give it to the court officer.
Yes,
A memo
please,
is
ma'am.
filed seeking dispensation of notice to R1. Memo is taken on record. Notice to R1 is dispensed with at the risk of appellant. There's a delay of 109. IA number 1 of 25 is filed to condone the delay of 194 days. Condone on condition that they not be entitled for interest for the delayed period. Admit file hearing TCR. Next.
Much
Number
obliged.
5, Nayak Krishna Venkataraman.
My lord, respondent number 1 kindly.
Come here. You shift this to here. That mic to this side and light to that side. No, light should not be on my face. Yes,
But respondent number 1 kindly notice may be dispensed with, my lord.
Memo is filed seeking dispensation of notice to R1 dispensed with.
Madam,
R2 is which company?
Respondent number 2 HDFC General Insurance Company.
HDFC.
Yes, BC Shivane Gowda.
Mr. H.S. Lingaraj is directed to take notice on behalf of the insurance company. IA number 1 of 25 is filed to condone the delay of 121 days condoned on condition. In this, wherever so-and-so is directed to take notice, in that you have to say the counsel for the appellant has served the copy of the appeal memo on the counsel for the respondent. In all the cases, similar order. Yes. Next, admit final hearing TCR. Next 6.
6, Gurudev Prasad.
Notice may be dispensed.
R1, our notice to R1 is dispensed with. R2 is dispensed with, memo is taken on record.
Yeah, United India.
Mr. Shankar Reddy C is directed to take notice on behalf of the respondent insurance company. Counsel for the appellant serve the copy of the appeal memo. Huh? Huh?
7904.
See, that's what I said, Shankar Reddy. That's, I number 1 of 25 is filed to condone the delay of 40 days condoned, admit final hearing TCR. Next. Yes, Sushmita.
7, Sushmita.
My lord, in this case, I appear for the appellant, my lord. R2 is SBI General Insurance Company, my lord. Kindly notice may be issued.
What is that?
R2 is SBI General Insurance Company, my lord.
Who appears for that, SPA? Mr. Jagdish. PS Jagdish. PS Jagdish is directed to take notice on behalf of the respondent insurance company. No, memo is filed seeking dispensation of notice to R1.
No, my lord. R1 and R3, they're necessary parties, my lord.
Notice to so-and-so. R1
Yes,
and
please.
yes. 8.
Much
Serial number 8, Pavan Chandra Shetty.
R2 is in Bajaj Insurance Company, my lord. R2 Bajaj Insurance Company. R1 I am filing a dispensation, my lord.
Memo is filed seeking dispensation of notice to R1 dispensed with Bajaj. Bajaj Alliance.
Bajaj Alliance.
HR Renuka is directed to take notice on behalf of the insurance company. A memo for that 1 and 3 memo is filed, I think. 1 and 3 or only one? One memo is filed. There is the IA number 1 of 25 is filed to condone the delay of 893 days. Condone for the reasons stated in the accompanying affidavit. Condoned on condition that they are not entitled for interest.
Obliged, my
Yes,
lord.
admit final hearing TCR. Some of the copies on the council.
Please, my lord.
Yes, next.
9, Nagaraja HR.
For appellant, my lord, we are filing memo for dispensation for R1.
You can take from there. Don't have to come out. Take the note. Memo is filed seeking dispensation of notice to R1 dispensed with. Which is the company? To R2?
New India Assurance.
New India Assurance. Mr. Ashok and Patel is directed to take notice on behalf of the insurance company. I number 1 of 25 to condone the delay 160 days condone on condition. That is, when I say condone on condition, like the earlier order, first order, like, yes. Admit file near in TCR. Next.
10, Pavanachandra Shetty.
My lord, R1, I am filing the dispensation.
Memo is filed for R1.
R2,
Next.
Royal Sundaram.
Royal?
Sundaram.
Royal Sundar.
Mr. Anup Sitaramaro is directed to take notice. There's a delay of 90 days. IA number 1 of 25 condone on condition. Next 11.
11,
Oblation.
Yes, Girish R. Baldari.
Girish Arbal.
Prepare for the appellant, madam. I filed a memo for dispensation notice to respond 1 and 2, madam.
Memo for 1 and 2. The memo is taken on record.
To respond number 3, madam.
Who is the 3?
Universal Sampo General Insurance Company.
Universal Sampo.
Universal Sampo, I can.
S.V. Hegde Mulkand is directed to take notice on behalf of the insurance company. Serve the papers on him.
Yes, ma'am.
I number 1 of 25 to condone the delay of 332 days condone on condition. Next 12.
12, Pavanachandra Shetty.
My lord, R2 is a United India Insurance Company. My lord, a pay and recovery order is there, my lord. R1, I'll take a notice, my lord.
Notice to R1. R2. Mr. Krishna Kishore is directed to take notice on behalf of the insurance company. IA number 1 for 100 days, because others have to go. So no condonation of delay in this. Notice to respondent 1 and 3.
1, my lord, I'll take, my lord. 3,
Not there, only 1.
Not one.
A notice to respondent number 1. Yes. 13.
13, V. Pradeep.
Insurance company challenging liability on the ground of my insurance claimants filed after lapse of 6 months, my lord, claim petition filed.
How much is granted?
Granted, my lord, 2,75,286.
It is submitted that the claim petition is filed after lapse of 9 months. In spite of the same, the court has considered and granted compensation. Considering the submission, same 50%, 4 weeks. Yes. Notice.
Deposit amount may be kept in FT, my lord, because the liability challenging.
We'll see.
Please,
Yes,
ma'am.
next.
Delay application in time, appeal filed in time.
I number 1 is filed to condone the delay. The same is not pressed since appeal is in time. Accordingly, I number 1 of 25 is dismissed as not pressed. Yes, next.
14, V. Pradeep.
The previous 2910 already granted stay, my lord. Call along with my lord 6402 of 2025.
List along with the notice has to be ordered in this.
Notice also ordered.
Ordered.
Ordered,
Why
my
is it
lord.
coming now?
2910, my lordship has been ordered.
Then why it is coming? Look at the order sheet. Why they have posted it today? No stay, Mr. Counsel.
So 29th, I am only represented, my lord.
29th list on 511. I think that day you were not having the file to tell the facts. That's how it is adjourned. That's why it is listed today.
In same, my lord. This case
Yes.
also maintained, my lord. After lapse of 6 months, claim
Case
petition.
of death or injury.
Case of injury, my lord. Sorry,
How much
death.
is granted?
1 lakh rupees, my lord.
Huh?
1 lakh.
So it is submitted that the claim petition is filed with a delay, and that aspect was not considered by the court, considering the same 50%. Notice to the respondent, stay. Yes.
Please, my lord.
15.
15, Nayak Krishna. Venkatram.
Respond number 1, kindly notice me.
R1 memo.
Respond
dispensed
number
with.
2,
Huh?
New India Insurance Company.
New India.
Insurance Company.
Mr. K. Nagarajaya is directed to take notice on behalf of the respondent insurance company. Admit final hearing TCR. Next 16.
16, Rajanna.
SRTC.
Who Mr. Dabali appears. Mr. Dabali is directed to take notice on behalf of the respondent insurance company, respondent KSRTC. Serve the papers on him.
Please.
Admit final hearing TCR. Next 17.
17,
Notice to
Rangegoda.
first respondent make kindly be dispensed.
Respondent number 1 dispensed with. Yes.
R2, my lord, Liberty General Insurance Company, Ravi S. Samprati.
Ravi S. Samprati is directed to take notice on behalf of the insurance company. Admit final hearing TCR. Serve the papers on him.
Please.
In all these matters, in all the cases, notice has to be served. Yes, the appeal memo. Case 19.
18, D. Vijay
My lord, I
Kumar.
am for the appellant, my lord, appeal by the insurance company. Complaint after 2 days. It is a case of self-fall. He went and dashed against the roadside electric pole.
Death or
Falsely-
injury?
After injury case, it's a case of injury.
How
After
much is
2 days, our jeep, our vehicle is falsely involved.
How much?
8,54,000 is awarded.
He submitted that there's a that the complaint is given with delay, and it's a case of self-fall, and vehicle, the insured vehicle is implicated in this case. Same, stay 4 weeks, considering the submission of the land grants to the appellant. It shall be stay for, that is on deposit 50%, 4 weeks, admit final hearing. No,
My lord,
notice.
before High Court, my lord.
Notice wherever you want. Yes,
Please.
next.
19, V. Pradeep.
Filing dispensation, respond number 2, my lord. Owner of the.
Memo is filed second dispensation of notice to respondent number
2.
Respondent number 2.
Insurance company challenging quantum, my lord. Case of death, my lord.
How much is awarded?
Well, it's awarded, my lord, 26 lakhs, 25,664 rupees.
26 lakhs.
Please,
So
my lord.
according to you, what is the admitted amount?
Admitted amount 14 lakh, my lord. 14 lakh.
Why, what is the,
My lord,
what is the difference?
In this case, my lord, they consumed alcohol, my lord. That is contributory negligence will come. That is
How
a
much
way-
will come? Half, 50% will come?
No, my lord. I will deposit 14 lakhs, my lord. They
No,
can-
no, no, don't deposit 14 lakh. It is submitted that there is a contributory negligence on behalf of the appellant. The same was not considered by the tribunal and granted the compensation. Considering the submission of the land counsel for the appellant, they shall be stay on the condition that they shall deposit an amount of rupees 18 lakhs, and on such deposit, the respondents are at liberty to withdraw as apportioned and as per the conditions laid down in the award. This deposit should be within 4 weeks. Yes,
Please,
next.
madam.
Notice to the respondent, yes. Why you are seeking dispensation to R1?
He placed expert before tribunal, my lord. Insurance company challenging quantum as well as negligence.
No, 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 I think something is wrong here. Mother represented by the children represented by mother. If it is dispensed with, if you look at it, the cause title,
Rupas, yes.
Rupa is the wife, deceased wife, children. You are seeking dispensation to the mother.
Sorry, my lord. Dispensation, respond number 5. I think.
No, this is only, in this case, memo is not to one.
I will correct it.
Dispensation to respondent number 5. Notice to respondents 1 to 4. Yes. Please look at the file and tell if the court officer, if he doesn't see what will happen.
But 20,
Lord, I appear for the appellant. The case of death, my lord, the deceased was traveling in the vehicle which is insured with the appellant as a workman. It was pleaded that the liability should have been restricted as per the WC Act. The tribunal has ignored it and directed the insurance company to deposit 16,61,400. The
As per the WC Act,
compensation,
how much?
8,31,920. We'll deposit 8,920.
It is submitted that the workman, while traveling in the insured vehicle, sustained died. And it is a case of the insurance company that they are only liable to pay as per the policy. But the tribunal had, as per the Workmen Compensation Act, but the court had granted the compensation as per the Motor Vehicles Act. Considering the submission, stay 4 weeks, 8 lakhs.
31,920 with interest.
They are entitled to withdraw the same as per the conditions laid down in the award. Yes. Yes. Notice, R8 is United India.
I take notice on Krishna Kishore.
Mr. Krishna Kishore is directed to take notice on behalf of the respondent insurance company. Notice to the other respondents. Yes, 21.
21, Millard, the appeal on liability, no permit, no valid permit. The tribunal has
Pay and
not.
recovery will not apply.
Pay and recovery will apply.
So how much is the amount?
Amount is 5,28,000
To
rupees.
deposit the entire amount. What you want is pay.
5,72,800.
No, I'm saying if pay and recovery applies, ultimately you have to pay. So 5 points, entire amount you deposit.
No, that is all, and the quantum is also under dispute.
Quantum is also.
He continues to work in the same employment. In spite of that, the
They
tribunal has
submitted
granted 2
that
lakh 60.
there was no
Deposit
permit to
50%.
the vehicle, and in spite of the same, the court had granted, had held that the insurance company is liable. Further, the insurance company is also questioning the quantum of compensation, considering the same. Stay on deposit of 50%, 4 weeks.
Before this
And
court.
on such deposit, the respondents are entitled to withdraw.
No,
Notice.
Miller, let the amount be deposited before this court. Let it be pending. Miller. Once the matter is decided, let them return. Let them come out with an application.
Let them design unnecessarily another round of litigation when they are entitled. Yes, 22.
22, Gonendra Raju.
Yes.
On behalf of appellant, my lord, case of injury, my lord, wherein you're challenging both, my lord, involvement of vehicle and also negligence. My lord, total compensation 9 lakh 5,000 is awarded, my lord.
It is the land council appearing for the appellant's offense that the involvement of the vehicle is in question, and also there is contributory negligence. Further, the quantum of compensation that is awarded by the tribunal is on the higher side, considering all this. Stay 4 weeks, 50% withdraw, permitted to withdraw. Yes, next. Notice to the respondent.
I am for filing dispend number 2, my lord.
23, Pradeep.
You have seen the file, and 2 is who?
Correct, my lord. So, respond number 2 is owner of
Memo is filed seeking dispensation of notice to respondent number 2, dispensed with, yes.
case of injury, my lord. Tribunal awarded 25 lakh 44,970 rupees awarded, my lord. So I will deposit, my lordship, 15 lakh rupees, my lordship.
On what ground you are before the court?
I am in quantum on the ground because the doctor assessed 25% disability, my lordship. Only on fracture, my lord, tear drop, fracture of C3 vertebral.
It is submitted that the quantum, the compensation that is awarded by the court is on the higher side. And the court has failed to appreciate the medical evidence. Same stay on condition of depositing 15 lakhs, and on such deposit within 4 weeks, and on such deposit the respondents are at liberty to withdraw. Notice to the respondent. Yes, 24.
Appear for appellant in this case.
24.
This is a claimant appeal, questioning the liability and also quantum money.
Yes.
They have dismissed the case against the insurance company on the ground that there is no DL.
Notice to the respondents. Yes.
Bajaj member. Insurance company is Bajaj. Bajaj Alliance. R2.
Mr. B. Pradeep is directed to take notice on behalf of the insurance company. Notice to the respondent. Yes. 25.
25.
Claimant's appeal, enhancement of compensation.
Raju, yes.
Which is the insurance company?
To United.
United Indian Insurance. Issue notice to respondents.
Dispense with is there?
No.
Liability is on whom? Give that file. Liability is on the insurance company. File a memo seeking dispensation of notice to 1. Write it and give. A memo is filed seeking dispensation of notice to R1. The R2 is
United India.
United India. Mr. PB Raju is directed to take notice on behalf of the insurance company. I admit post for final hearing call for the TCR. Serve the papers on the council and give the memo also right now. It's 26.
26. Gurudev Prasad.
Notice to R2 may be dispensed.
Yes, notice to R2 dispensed with.
If court okay.
Mr. B. Shivanagowda. Shivanagowda appears for if court okay.
If court okay. ಶಿವಣ್ಣಗೌಡ ಬರ್ತಾರೆ.
Shivanagoda is directed to take notice on behalf of the respondent insurance company. Admit final hearing TCR 27.
27, ಪವನಚಂದ್ರ ಶೆಟ್ಟಿ.
Yes. Huh? Manjula N. Tejashvi is directed to take notice on behalf of the respondent and grounds for the appellant should serve the copy of the appeal memo. Admit final hearing TCR. Yes. R1 is there. A notice to R1. No final hearing, notice to R1. Just R2 so and so, R1 notice, nothing, no admit, nothing. Yes. 28.
28, final hearing. Bhunendra Raju.
Respondent number. Kindly be taken up.
2 months.
May kindly be taken up next week. I appear on behalf of Raju. Raju is held up somewhere. Will be taken up next week.
This is matter on 27th of November. Yes.
29, Gurudev Prasad.
Case of injuries.
Where is Mr. S.V. Hegde?
Hegde is-
Yes, my lord, I am ready.
Injuries are in para
Please come to
19.
the table.
Date of action 26/12/19.
Table.
Injuries are at para 19, internal page 10. Fracture of left hip and dislocation. Table is
My lord,
This will grant
discussion is-
50,000
My lord,
50.
Yes, sir.
pain and suffering.
That can be done.
Yes. Medical expenses.
as it is. For 7 days he was in the
1
hospital.
minute. How many days you were in the?
7 days.
7 days.
Huh?
7 days.
So as it is incidental
Yes, yes.
expenses also 7,000. Then future medical expenses,
Future medical expenses,
what is the evidence of the doctor?
60,000, the doctor says 50,000.
Anyhow, 50,000 will confirm.
Yes.
Then what is the evidence of the doctor with regard to the disability?
Disability 45% to the limb and 15% to the whole body.
What was taken?
Court has taken 15%,
My lord,
12%.
12% has been taken.
12%.
Because he was not a treated doctor, accordingly 12% has been.
Income was taken at
14,000, correct.
14,000. Then what will be enhanced in this?
15% disability has to be considered.
My lord, he was not a treated doctor.
45%.
He was not a
No, if he is not a treated doctor,
Yes,
when you consider 12%, why not
But
15%?
only for the purpose of disability assessment, he has come, he went to that doctor.
No,
Accordingly, my
correct.
lord,
Not
yes,
necessary
your
that
lordship, my lord, I
we will take 15%. So it is future loss of income.
Yes.
Which year is the accident you said?
Yes.
2014.
14,000 is correctly taken.
1 minute.
19.
2019.
But that is the 14,000 my lord, income.
So 14,000 into 12 into what is the multiplier?
15.
15 my lord, 39 years.
No, 15 into 15 by 100. It comes to 3,78,000.
Yes.
Then loss of income during laid up period,
My lord, it
It has not been given.
Not given.
so 14,000 into 3.
Yes.
42,000.
And loss of
Amenities, my lord,
amenities
10,000 has
only
been given.
10,000.
That needs to be enhanced.
Yes.
Loss of amenities another 20,000.
That's all.
It's coming to 7,02,572 against 5,19,972. Please come. Agreed with the award passed in BC number 956 of 2020 dated 15th March 2023. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 10 lakh for the injuries sustained by the claimant in the accident. The tribunal has awarded the compensation as per the table given below at paragraph number 27. There is a table, you please extract the table. The learned counsel appearing for the claimant submits that the court had failed to grant reasonable compensation. When he had sustained, where do you get the injuries?
Paragraph
When he had
19.
he had sustained
22 discussion is there.
22.
Yes, madam. Paragraph 22.
That the petition had mild limping gait, restricted left hip movements. The court under the head of pain and suffering had granted only 15,000. No amount is granted under the head of loss of income during the later period. Further, it is submitted that when the doctor has deposed that the disability is 45% to the limb and 15% to the whole body, the court without any basis has taken 12%. 12%.
12%.
Court had taken 12%. It is submitted that on all counts, the compensation needs to be enhanced. Next, having heard the learned counsel appearing for the respondent insurance company submits that the tribunal had rightly granted the compensation. There are no grounds to interfere. Next, having heard the counsels on either side, peruse the material on record. Considering the injuries that are sustained by the claimant under the head of pain and suffering, this court is granting an amount of rupees 50,000. Medical expenses, incidental expenses, no interference, future medical expenses, no interference is called for. Coming to the loss of earning during the later period, considering that this accident had taken place in the year 2019, for 3 months, 14,000 into 3, this court is granting 42,000. Then coming to the disability, when the doctor has deposed it is 15%, why the court had taken 12%, there is no explanation forthcoming. In that view of the matter, this court is taking the disability at 15%. Hence, under the head of future loss of income, 14,000 into 12 into 15 into 15 by 100 is 3,78,000. Then coming to the loss of amenities, considering the 15% disability, this court is granting 30,000. In the light of the law laid down in Mekala versus so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 7,02,572. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 5,19,972 to 7,02,572. The enhanced amount shall carry 6% interest. You will have a pro forma audits. Take it from the appeals. Yes, next.
Number 30, Prakash HC.
There's one more appeal, 3 appeals arranged for the same. That only 2 cases have come. 1693 of 24.
We can deal with these 2, whatever are listed.
He is not coming. He told me.
Huh?
He is not coming up. Okay. He told
He's not coming to the court.
Today he is not. Your lordship, can you have it on Monday?
List along with so and so.
1693.
List to this matter on 26th of November.
31, Mr. Prakash. 31.
For respondent, liability fixed against the owner of the vehicle, my lord. An insurance company exonerated before MSCT.
So what I'll do, whoever doesn't turn up, I will list the matters in the month of January. Because there are people who are waiting. If the people who don't want to come, why should we accommodate them? List is no representation on behalf of the appellant. This is matter in the month of January.
Please,
so that we can hear the matters where people are ready. Yes, 32.
32, Syed Abdul.
I am for respondent, my lord.
31, my lord.
Huh?
31.
Yes, Prakash,
please. Sorry, my lord.
Yes, give the file.
Claimant's appeal.
death case, my lords, the tribunal has not awarded towards loss of consortium, loss of estate, my lords, and towards love and affection has awarded total 75,000.
Let's see the table.
My lords,
Let's see the table. So you have no issue on loss of dependency.
no, my lords,
So let's calculate. It is 6 lakhs.
please.
How much medical expenses?
Medical expenses, my lords, he was hospitalized for 46 days, my lord, 40 days, my lords.
Medical expenses,
He was hospitalized for
1 minute, 20,827. How many days she was in hospital?
40 days, my lords.
Incidental, 14 or 40?
40, 40.
40.
Please, ma'am.
So incidental expenses, 40,000.
Yes, I mean, conveyance and traveling,
But
yes.
court already granted more, 35 plus 10, 45 is granted.
Please, my lord,
So the same we will retain 45.
please, ma'am.
So then coming to the loss of consortium, how many are the claimants?
Loss of consortium, it has to be more, my lords, 40,000 each.
How many are the dependents?
3, my lords.
3
members,
into
ma'am.
44.
1 lakh.
One lakh 32.
Please, my lords. And towards attendance charges,
Now,
it may
1
be-
minute, the funeral expenses, 36,000. That's it.
attendance charges may be, my lords.
No. That is whatever we grant.
Please.
It is 1,000 per day of hospitalization.
Please, my lords.
Yes, it's coming to 8,43,827 against 7,65,827.
Please. Lords, towards liability, the liability is on the own rider of the bike, my lords. Insurance company may be directed to pay and recover, my lords. The
On
honorable
what
Supreme
ground?
No DL, my lord. As on date of accident, there is
Oh,
no.
it's DL. So
DL.
then pay and recover will
Yes,
happen.
ma'am. Date of accident, my lordship, previous amendment, my lord. Pay and recovery may be, my lordship. May be.
Please. Agreed with award passed in MVC number 939 of 2021, dated so 6 December 2023. The claimants are before this court seeking enhancement of the compensation. Land counsel appearing for the claimant submits that the tribunal has not awarded a reasonable compensation under the head of under the head of loss of consortium, funeral expenses. It is submitted that the liability is fixed on the owner of the vehicle as the rider or driver.
Rider, ma'am.
Huh?
Motorcycle.
Rider was not having a valid driving license. It is submitted that in the light of the settled law, even if the rider of the vehicle is not having a valid driving license, still the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Owner of the vehicle. Land counsel appearing for the respondent insurance company submits that the tribunal has rightly awarded the compensation, and both on the liability and on the quantum there are no grounds to interfere. But having heard the counsels on either side, peruse the material on record. The tribunal has awarded the compensation as per the table given below. That is at paragraph 31. Extract the table. There is no dispute with regard to loss of dependency, medical expenses, and the incidental expenses. Coming to the loss of consortium, as there are 3 claimants, 3 into 44, 1,32,000. Funeral expenses 36,000. And in the light of the law laid down in Mekala versus so and so, legal expenses 10,000. Altogether, the claimants are entitled for an amount of rupees 8,43,827. Then coming to the aspect of liability, as though the rider is not having a valid driving license, still the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle in the light of the law laid down and laid down by the Honorable Apex Court in Swaran Singh's case. Next paragraph. And accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 7,65,827 to 8,43,827. The insurance company is liable to pay this amount and recover the same from the owner of the vehicle. The enhanced amount shall carry 6% interest.
Much obliged.
Yes, next.
32. Sayyid Abdul Sabur.
I am for respondent.
Hmm.
It's a case of death, my lord.
1 minute.
Pill and rider.
One. Yes.
It's a case of death, my lord.
Mm.
The tribunal has awarded, taken 50% as income deducted
Let us
from.
see what is the age.
Age is
Regarding
50.
one submission regarding liability, my lord. Insurance policy has been issued act policy.
Act policy.
Pillion rider not cover, my lord. My friend, my lordship, they have not, even though they have appeal memo, they have not mentioned this liability shifting, my lord. Only insurance company has been exonerated. Liability fixed to the
Pass on to owner.
owner.
So you are seeking enhancement against the owner only.
Because there is a
Act policy.
pendency in the apex.
So we have to only deal with the enhancement. Whether the owner is served.
Yes, it's served
Yes.
and deposited.
So let's see.
Death is on 19/7 to 21, my lord, date of.
What is the age of the deceased?
52 years. 52.
Conclusion.
What is the age?
55 years.
52 mentioned again.
They have claim petition, they have filed 52 years. His conclusion, my lord, 55 years age.
Hmm.
As per
Postmortem. 55 years. Income is taken.
Income taken is 15,000, my lord.
Correctly taken.
The correctly taken. 1/3 to be deducted, but 50% income has been taken because she's spinster. She's not spinster. She's married. She was married. So the 1/3 to be deducted from the.
Yes. So.
And future prospect to be added 10%.
No, 15,000. Future prospects 10%.
10%.
10% future per.
11 is the multiple.
It comes to 11,000. Into 12 into what is the multiplier?
11.
It comes to 14,52,000. Loss of dependency. 44,000, 36,000.
Yes.
10,000. It is coming to 15,42,000
600.
against 11,03,000. Please come. Agreed to the award passed in MVC number 899 of 2021 dated 1st February 2023. The claimants are before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at paragraph 22 extracted. When counsel appearing for the claimant submits that the tribunal has fixed the liability on the owner of the vehicle as the claimant is a pillion rider, not claimant, the deceased was a pillion rider and it was an act policy and the pillion rider is not covered. When it comes to compensation, the court had rightly taken 15,000 but deducted 50%. It ought to have deducted 1/3. Even under the other heads also, the compensation that is awarded by the tribunal is not just and reasonable. Next para. When counsel appearing for the respondent insurance company submits that insurance, the liability is on the owner of the vehicle. Though owner is no representation on behalf of the, no wakalat is filed on behalf of the owner. Next para. Having heard the counsels on either side, there is the material on record. The court had rightly taken 15,000 as income. Considering the age of 55, with your 10% future prospects would come to 1,500, that is 16,500. As rightly contended with the land counsel for the petitioner, the court has, the auto have deducted 1/3. 1/3 is 5,500. Then his contribution to the family would be 11,000 into 12 into 11. Under the head of loss of dependency, they're entitled for 14,52,000 towards consortium. 44th loss of consortium, 44,000. Funeral expenses, 36,000. In the light of the law laid down and make allowance, also 10,000. Altogether, the claimants were entitled for 15,42,000. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 11,03,000 to 15,42,000, and the enhanced amount, the insurance, the owner of the vehicle is alone liable to pay the compensation. The enhanced amount shall carry 6% interest.
33 urgent, 34, Kailash Shankar.
Mainly call along with the MFA 3624 of 24 man.
What is it?
This is the one more action, arising same action.
What happens? We can deal with this today.
There are two connected matters.
I can understand. It's only for enhancement. It can be why two claimants have to be heard at the same time. Whatever listed, we can complete it.
Yes, ma'am.
Where is Renuka? You said you are going to take time to her.
Mr. Renuka.
List along with so-and-so in the month of December. Don't give the date. Whoever asks for adjournment, I'm not going to give a date.
35, Syed Abdul Sabur.
My lord, it's serve unrepresented.
SBI General Insurance, who appears? Pradeep?
Pradeep.
Yes, Pradeep is directed to take notice on behalf of the insurance company. Serve the papers. Serve the papers on him.
Yes, I'll serve.
List is, it's a case of death or injury.
Injury, my lord.
List this matter on 19th of November.
Macho.
Yes, 36.
36, R. Shashidhar.
36, my lord, he held up in other court, my lord, kindly pass over.
Pass over. Yes, 37.
37, yes, Girish.
You appear for IAG.
Already they forwarded the Nokalat, my lordship. Today I am to going to file.
Yes.
Morning they have called and informed me.
Yes. Mr. Janardhan Reddy is directed to take notice on behalf of the respondent insurance company. Yes, 37.
It's a case of injury. Multiple
Come to the table.
ligament fracture.
Come to the table.
Table in page number 21, lordship.
Yes, what are the injuries?
Multiple ligament injury and patella. Implants fracture patella. Implants are
Yes,
inserted.
Janardhan Reddy, 50,000.
Yes, my lordship. Pain and suffering is only 15,000 is awarded.
50, I'm saying.
Yes, my lord.
Yes. Then coming to the, how many days was in hospital?
3 times as inpatient, totally 16 days, lordship.
Incidental expenses, 16,000.
Medical as it is, my lordship.
Medical as it is.
Amenities 15,000.
1 minute, let me complete this. Expenses. 739. Then loss of income during later period.
2 months, another.
They are awarded only because multiple implants are inserted.
Now, how many, for how many months it is granted?
2 months.
2 months.
Which year is this accident?
2019.
19, my lordship.
14,000. 14,000 into 4. 26,000. Then, what is the evidence of the doctor with regard to the disability?
Disability as assessed 53% is a particular limb and 18% is the whole body.
What was the
Tribunal taken 15%, my lordship.
Why not 18? Take 18. No, why? What I'm not able to understand is doctor's evidence. Just like that, you take something. Why the doctor? Court only should make the guesswork. There should be some basis. So loss of future income. 14,000
into 12 into 17 into 18.
into 17 into 18 by 100. It comes to 5,14,080. Then disability, loss of amenities, how much is granted?
15,000 minutes.
Another 15 will grant.
Yes.
It comes to 9,67,819 against 7,93,139. Please come. Agreed with the award passed in MBC number 1242 of 2020 dated 19th August 2023. 23. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 19. When counsel appearing for the claimant submits that when the doctor had deposed that the disability is 53% to the limb and 18% to the whole body, court had taken 15% without any basis. When he had sustained fracture injuries, the court had granted only 15,000 towards pain and suffering. So even under the head of loss of income during the later period, only 2 months was considered. Further, loss of amenities for a disability of 18%, only 15,000 is granted. It is submitted that on all counts, the compensation needs to be enhanced. When counsel appearing for the respondent insurance company submitted, the tribunal had granted a just and reasonable compensation and there are no grounds to interfere. Next, having heard the counsels on either side, there is a material not record. Considering where are the injuries you get? As per the claimant had sustained multi-ligament injury right knee and dislocation and other injuries all over the body. Hence, on the head of pain and suffering, this code is granting 50,000. Court had under the incidental expenses for hospitalization of 16 days, this code is granting 16,000. Medical expenses, as it is, no interference is called for. Coming to the loss of income during the later period for 4 months, 14,000 into 4, this code is granting 56,000. Coming to the loss of future earnings, when the doctor had deposed that the disability to the body is 18%, the court without any basis had taken 15% as disability. 14,000 into 12 into 17 into 18 by 100 is 5,14,080. Loss of amenities for 18% of disability, this code is granting 30,000. In the light of the law laid down in Mekala House so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 9,67,819. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 7,93,139 to 9,67,819. The enhanced amount shall carry 6% interest.
38 or Shashidhara?
38 also, my lord. The 6 pass over, my lord. 48. 48, my lord. 6
Pass over. What is this? It's a case of death.
Injury.
We will make the calculation.
We can.
Afternoon, we can pass orders. Give the
Please,
file.
Date of accident 26/4/2021.
Keep quiet. Continuously they're talking.
So advocates are requested to don't talk. Please maintain
some silence.
Please maintain silence.
Yes.
26/4/2021 is the date of accident, Mela.
20? No, let's go to the table.
26/4/2021.
1 minute. What are the injuries? Please come to the.
Fracture of trochanteric right femur. Doctor says, 28 to 30%.
No, we are on pain and suffering. Come to the
Please,
table.
table,
So
madam.
how many are the injuries? Fracture injuries?
Only one fracture, madam.
So we'll grant 40,000.
Please, 10,000
Then,
is granted. Amenities,
medical
5,000 is granted.
expenses, medical expenses.
10,872.
And how many days he was in hospital?
He was 6 days in.
Incidental expenses, how much was granted?
Madam, incidental expenses, madam, only 5,000, 6,800.
6,000?
800.
He was in hospital for?
6 days.
So that is sufficient.
Amenity was.
No. Then we will come to
Loss of
earning during laid up period.
That was not granted.
How many, considering injuries will grant 4 months.
Please.
Which year is the accident?
21, madam.
21 is 15,000. 15,000 into 4, how much?
60.
Yes. Then coming to the future loss of income.
Court has taken 10% disability.
What was the evidence of the doctor?
28 to 30%
Permanent disability, my lord.
To the whole body?
Paragraph 24 of the judgment, my lord.
To the whole body?
No, he has not stated that, madam.
Let's see.
Physical impact.
20?
28 to 30% in
No.
paragraph
Which?
24 of the judgment.
Let's read PW2 specifically because
Please, ma'am.
that is permanent physical disability. Let's look at the injuries, then we'll understand.
According to me, the tribunal disability assessed by the tribunal is also a lesser side. At least 15% has to be taken.
Femur, my lord, fracture of subtrochantic right femur.
Right femur.
10% is considered.
10% is taken, madam. That is on the lesser side.
We will
But the
take
disability assessed by the doctor is also on the higher side.
20 we will take.
That is also, I said, madam. According to my madam, 15% or 16% your lordship can take.
Lord, is
That is
suffered,
the
my
only-
lord, femur fracture. Disability, my lord, considered.
We have to understand why should we discard the evidence of the doctor? There should be something. Is it contrary
He
to
has
any
not assessed the
parameter?
limb disability in this case. That is the reason court has taken 1/3. But that is also on the lesser side.
When it comes
Based
to
on
the
our,
femur fracture is what?
madam, this is the femur, madam. This is the thigh bone. But the disability, what the doctor says that 20 to 30%. Madam, even assuming that the amputation of below the leg, 40% as per the schedule, how can it be the 30%, madam?
No, that's why 30% is
therefore,
on high, sir.
15% or 16%, your lordship can take 16%.
We will take, because when the moment 20 comes, again,
No, not
future
only that,
prospects
the
and all.
medical jurisprudence, what we have, the decision of the judgments.
Normally, my lord, this court considered 20% disability
Yavadar judgment try will.
So,
regarding femur fracture.
no, what is this, income is 15,000.
15,000. Court has taken 14,500.
Into 12, into, what is the multiplier?
17.
17.
Into 19. To get away with that 20%, we will take 19. 19 by 100.
Pain and suffering, my lord.
40,000.
No, we will take 50 femur fracture, 50. 15,000 into 12 into 17 into 19. It comes to 5,81,400. Then loss of amenities, how much is granted?
Amenities, my lord, only 5,000 is granted. Another 30.
We'll grant 40,000.
Loss of amenities, hotel, they are not.
Hotel, special amenities.
5,000. 5,000.
So shall I dictate or you want me to dictate in the afternoon?
Can we dictate?
Yes, please come. Agreed with the award passed in MBC number 673 of 2021, dated 22nd August 2023. The claimant is before this court seeking enhancement of the compensation. Next, the tribunal has granted the compensation as per the table given below at paragraph number 29. Then counsel appearing for the claimant submits that when he has sustained a femur fracture under the head of pain and suffering, court had granted only an amount of rupees 10,000. Further, according to the doctor, the claimant had sustained disability 28 to 30%, and the court had taken 12%.
10%.
Court had taken 10%. the accident had taken place in the year 2021, but the court had considered the income at 14,500. 14,500, which is on the lower side. It is submitted that on all counts, and even under the loss
laid
of
up period.
income during the later period also, the proper compensation is awarded.
Was not granted.
It was not at all granted. Loss of income in the later period was not at all granted. It is granted 1,800.
No, special conveyance and attendance.
Special amenities 5,000. Loss of
Attendance
income.
charges 1,800. Loss of income, please correct.
No, it says loss of later
Please.
period. Is not properly granted. Food and nourishment, then this 8,000, I think the incidental expenses, 5 to 6 days he was hospitalized. So we will make it 6,000. Let me calculate first.
Laid up period, my lord, only
No, that I have
1,008.
calculated, that I have given 4 months.
Please. So less 1,800.
That I am doing
Same.
it. That I am doing it. It comes to 7,58,272 against 3,30,270. So what did I say? Or properly, court has not granted a reasonable amount. It is submitted that on all these counts, the compensation needs to be enhanced. Ex-parent counsel appearing for the claimant submits that the tribunal, the doctor has appearing for the insurance company submits that the tribunal, the doctor has deposed that the disability is 28 to 30%, which is on the higher side, and the court had rightly taken 10%, and on all other counts also, the compensation that is awarded by the tribunal is just and reasonable, and no enhancement is called for. Next, having heard so and so, there is the material on record. Considering the femur injury, this court is granting an amount of rupees 50,000 at the head of pain and suffering. Medical expenses, there are no grounds to interfere. Incidental expenses, as he was in hospital for 6 days, 6,000. Loss of earning during the later period, considering the income as the accident had taken place in 21, the 15,000 into 4, 60,000. Coming to the future loss of income, when the doctor had deposed that the disability is 28 to 30%, and it is a femur injury, and the court had taken 10%. The percentage the court had taken and the percentage the doctor had deposed, both are not inappropriate. Hence, this court is taking the disability at 19%. 15,000 into 12 into 17 into 19 by 100 days, 5,81,400. Towards loss of amenities, considering the femur injury and the disability of 19%, this court is granting 40,000. In the light of the law laid down in Mekala so and so, legal expenses 10,000. Altogether, the claimant is entitled to 7,58,272. The appeal of the claimant is partly allowed by enhancing the compensation from 3,30,270 to 7,58,272. Enhanced amount shall carry 6% interest.
Much.
Much of it.
Yes, next.
39. Syed Abdul.
Yes.
Appellant in this. It's a case of death, my lord.
In this, there is some confusion, my lord, regarding the death of the petitioner, my lord. During the pendency of the claim petition, petitioner Manjunath died.
No. What did the court do?
Court says, my lord, there was no nexus between the injury sustained and death.
That's
And, my lord, here you
but then you granted loss of estate expenditure.
estate has been granted, my lord. 4,65,000 has been granted under the said head.
So no, that issue will not go because there is no, your appeal is not there.
Yes, it is
So
not
whether
there.
this amount granted is correct or not is the only question.
Yes, madam.
Yes.
But here only question, my lord, I sent the papers, my lord, wakalat is awaited. So at least 2 days time may kindly be granted. Next week it may be taken and
This matter on 19th of November. You can file after a week also. I'll grant you time.
because of this confusion.
Yes,
my
yes,
lord.
19.
And his age was aged about 66
No,
years.
all not about all that because all these
Not
matters
taking
cannot be relisted.
My lord,
That is
I'm
what
not
I'm
taking
telling.
time in any matter. I have not taken any time. My lord.
Did I say so?
No, not like that.
Yes. Next.
Next week, my lord.
Gurudev Prasad.
I am only referring that I will not give any short date for any of the matters because I want other matters to be listed who want to argue. Yes. Yes, Mr. Pradeep.
Ready.
Case of?
Case of injuries.
Please come to the
Injuries are
table.
Para 20, yeah, internal page 20, injuries are there. And
Not injuries, where is the
4
table?
fractures, my lord.
4 fractures.
Let's see the table.
Table is in internal page 33.
Hardship reference, I will just
Take that.
But I have not written what is the enhancement. Lord Senior wants to argue.
So,
Para 43.
as far as pain and suffering are concerned,
75 is rightly granted.
rightly granted.
4 lakhs all on.
No, 40,000 and above another 3.
30.
So,
70.
75 is
75
awarded,
is
so we
awarded.
will confirm it at pain and suffering, 75,000.
Yes.
Hmm.
Laid up period.
How many days he was in hospital?
10 days.
10 days he was in the hospital. All he's a mason.
No.
20,000
It might
already
be-
granted, my lord.
20,000 is granted, which is on the higher side, that also we will not interfere.
No,
Then
31,000.
No, 20,000.
20,000 at conveyance and all.
Conveyance food and.
Conveyance and all.
20, that is reasonable, not reasonable, excess, but anyhow, we are not interfering with
Yes,
that.
yes.
Then loss of income during the later period,
2 months, my lord.
At least 6 months mason. Your lordship kindly see he has both right and left hand are fractured and also calcaneum.
what is
and
which year is
pubic
the accident?
My lord,
2022.
15,500 already taken,
So 15,500
already considered.
into 5, it comes to 77,500. Loss of income during the later period,
Yes.
77,500. Then future medical expenses according to the doctor,
Doctor has not said anything,
Not-
but he has to undergo operations. Court has given only 20,000.
another 20.
Yes.
Doctor has not stated anything, my lordship.
He said he has to undergo.
Another 10,000.
Yes.
30,000.
2 fractures are malunited.
Yes, 40,000. Next, loss of future earning. What is the evidence of the doctor?
Doctor
Upper
says
limb,
for
I-
so far
I-
as
I
upper
written
limb
all
is,
this in the
upper limb,
Where?
Written.
upper limb is concerned.
55%
both
upper
right
limb.
and
20% to the
55.99 and lower limb 20%.
Total
is
75%.
75%.
75% to
Upper
the
limb, my
limb.
lord, upper limb 55%, it comes, my lord, 13.5%.
13 point?
5%.
That is 1/4.
1/4.
Ah.
In lower limb is concerned, my lord, 6.6%. If,
To the whole body.
Whole body.
So it will come to
20% only, my lord, 20.
20, it crossed 20.
25.
So once it crossed the cap,
20
then it has
point
to be,
something point, my lord.
it's coming to 20.1.
That's what, my lord, 20.1.
Your lordship kindly pay internal page 27.
Hmm.
Yeah, X-ray noticed intra-articular fracture right
No,
distal
you
and
do you
radius.
do, no, you don't deny this evidence of the doctor, limb disability.
Shows malunion, fracture distal 1/3, distal and radius shows malunion, both right and left
No,
hands.
doctors, no, he is making submissions basing on the doctor's evidence.
No,
You can't deny it.
But he
Doctor
says.
said, disability to the limb, upper limb is 55, lower limb is 20.
No,
So
that-
55% 1/4, 20% 1/3.
But his
It's coming to 20.
His calculation is 28.65% to the whole body.
But that's not the way we calculate.
Combined upper limb and.
No, we have to take his, what is limb disability. He must have taken even 55% also, 1/3.
I leave it, but they.
So, no, anyhow, I'll grant future prospects in this.
Yes.
Yes. So what is 15,000?
500.
500. What is the age?
29 years.
29 years, 17 months.
So 40%.
Please. 6,200.
6,200. That is 7 plus 21,700.
700.
So 21,700 into 12 into
17 multiplied.
17.
into 12 into 17 into 21.
20%. 20%.
1 minute. 21,700 into 12 into 17 into 20.1. It comes to 8,89,000.
786.
786. Then
So amenities.
amenities not granted.
Granted, 30,000.
Loss of amenities 30,000. Yes.
Future prospects all adding. my lord,
Another-
30,000.
We will take 10,000.
Please.
Medical expenses as it is, 6,70,000.
Yes, ma'am.
Legal expenses, 10,000. It's coming to 20.1. It's coming to 18 lakhs 12,286, correct?
10,000 litigation.
10,000 is also added, 18 lakhs 12,286. Please come. Agreed with the award passed in MVC number 1214 of 2022 dated 16th October 2023. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at page 43. Land counsel appearing for the claimant submits that when the doctor had deposed that the disability to the whole body is 28%, the tribunal has failed to consider the same. Further, as he is a mason, considering the grievous injuries that are sustained by the claimant, the tribunal had granted the loss of income during the later period only for a period of
2 months.
2 months. Even under the other heads, so the loss of amenities and other heads of future medication, also the evidence, the amount that is granted with the tribunal is not just and reasonable. Land counsel appearing for the respondent insurance company that the tribunal has rightly arrived at the compensation and rightly granted the compensation by considering the evidence on record and no interference is called for. Next, having heard so and so, there is a material on record. As far as the pain and suffering, medical expenses are concerned, no medical expenses and incidental expenses are concerned, no interference is called for. Then coming to the loss of income during the lead-up period, considering the injuries and the occupation of the claimant, this court is taking for 5 months, it comes to it comes to 77,500. Then the loss of future income, when the doctor had deposed that the disability is 55% to the upper limb and 20% to the lower limb, but the whole body disability cannot be 28%. Taking 1/4 from the upper limb and 1/3 from the lower limb disability, this court is taking the disability at 20.1%. Hence, taking the income at 15%, 15,500, future 15,500, 15,500. Future prospects at 40% will come to 6,200. Then the income is 21,700 into 12 into 17 into 20.1 divided by 100 is 8,18,786.
89,000.
Huh?
89,000.
8,89,786. Then the amenities, this court is granting an amount of rupees 40,000. In the light of the law laid down in Meghalaya also so and so, legal expenses 10,000.
Future medical expense, another 20,000.
Future medical expenses, this court is granting an amount of rupees 40,000. In the light of the law laid down in Meghalaya also so and so, expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 18,12,286. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 14,78,400 to 18,12,286. The enhanced amount shall carry 6% interest. Yes.
Permits, serial number 31, want to make some submission. That 31 disposed of. That 73-year-old death of 1/3 deducted owner liability fixed against owner of vehicle. I have not prepared in appeal. Lordship has passed pain recovery order.
No. In that pain recovery is not in 73.
No, my lord.
He has confirmed his,
31.
huh?
Seal number 31, not 32, Sabur's case, not Sabur's case. my lord. Before that, S.V. Prakash.
Huh.
That, I want to say something on that. And 73-year-old, my lord, death of, my lord. Major son and married daughters are the claimants. Tribunal has deducted 1/3 towards personal expenses. Because we have no option to file appeal, my lord, because liability fixation is the owner of the vehicle. Lordship has enhanced 1 lakh. That requires for hearing, my lord. This is a-
31. This is matter on 19th of November and for being spoken to. Yes, next.
Sorry, my lord.
Yes. Your colleague was here.
Please, my lord, but I love
Yes,
it,
yes.
sir.
41. Nagaraj Hegde.
For appellant.
Hmm.
Case of injury.
Come to the table.
Amputation of
Come to the table.
25, page number 23. 23.
Hmm.
12,500 has been taken.
1 minute. Pain and suffering. Amputation till?
Above name.
And then pain and suffering.
Lord, 50,000 is granted.
Lord, one is.
That is, how much we are granting one for this amputation, pain and suffering?
Lord, Honorable Apex Court, Lord, in case of Lord Ayush, pain and suffering, Lord, for 100% disability, Lord, 10 lakh has been awarded.
Huh?
Rupees 10 lakh has been awarded. Permitted to know.
Yeah,
What has happened, Lord, the tribunal has taken, Lord, 80% disability to grant the compensation.
What is the age?
40 years as on the date of accident.
1/4.
140.
40. 40.
No, I mean,
amounts to
practically,
more
it has 100% disability.
Disability is taken at 80%.
But functional disability is 100%.
Therefore, they are entitled for future prospects, which is not done by the tribunal.
But it is done by the tribunal. 25% has been taken. For 40 years more, it is to be 40% more. Up to 40 years, 40% future prospect has to be added. But tribunal,
That we will take.
Yes, ma'am.
I am on this pain and suffering. That case and this case you can't equate.
Correct, Lord. But
So,
basing on the age,
pain and suffering,
1
we
lakh.
will not grant 10 lakh.
No, not 10 lakh, Lord. Just basing on the age, my Lord.
Yes,
I am
yes,
just,
we will grant 1 lakh for pain and suffering. Medical expenses as it is. 2,75,085. Then incidental, how many days he was?
9 days.
Already court has awarded 20, which is on the higher side, and you will not interfere. Then loss of income during later period.
Granted.
How many months are considered?
5 months.
We will consider another 2 months.
Please.
Oh, how much is the income?
12,500 as per the chart.
2018?
2018 accident.
100 into 7. It comes to 87,500. Then loss of future income.
Yes.
12,500 plus 40% future prospects. It comes to 5,000. That is 17,500 into 12 into
15.
15.
It's coming to 31,50,000. Then loss of amenities,
50,000 is granted, my lord.
another 50.
Please. Ma'am.
Or for artificial limb, my Lord, usually, my Lord, for in the application case.
What was the doctor's evidence?
In the evidence, he has not stated about
Not
it.
stated.
But considering the, my Lord,
Under future medical expenses, how much?
not awarded.
Not awarded.
Not awarded, how much?
1 lakh. Ma'am.
$15,000. It's coming to 69 lakhs, 25,085. Against 27 lakhs, 07585. Now, in this, tribunal has taken 80% disability.
Yes.
It has not granted future prospects.
No.
No future
They have
prospects.
considered 25%.
Huh?
25% they have considered.
Oh, 80% disability was, whole body disability was taken as 25%.
Future prospects is added 25%.
25%, not 40%. Yes, 25%. And income is taken at
12,500.
12,000.
Not 80% is excessive.
Huh?
80% is excessive.
No, above the knee, it is like functionally is.
100%.
That's what I'm saying. Please come. Agreed with the award passed in MVC number 15 of 2019. No, these are all final hearings. You should have asked her to come. No? Today will take. Agreed with the. Okay. Agreed with the award passed in MVC number. We requested for somebody for the from the board. So many people are. Agreed with the award passed in MVC number 15 of 2019 dated 17 January 2023. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below. The learned counsel appearing for the claimant submits that. Where do you get this injuries and all?
For the
That the claimant had a crushed injury,
Page number 25.
35 into 15 centimeters and bone deep over the right lower, starting 2 centimeters below the right knee joint. Abrasion, reddish 4 into 3 centimeters over front of the right hand, 12 centimeters below the right wrist joint. As per the opinion of the
Below
doctor.
knee, sorry.
Huh?
Below knee.
You said above the knee.
No, sorry, my lord, it's a below knee, but even my lord, for below knee also, my lord, the Honorable Apex Court has taken, my lord.
Then it is a schedule injury as per WSA.
No, sorry, my lord,
50%.
I'm relying upon one judgment of this Honorable Apex Court. Wherein, my lord, for below knee, my lord, the 90% has been considered. I'm very sorry. Page 14, my lord.
When you're carrying a judgment about below knee, why did you say above knee? And when I'm making the calculation, you have kept quiet.
Sorry, my lord, in my synopsis, I have written as above knee, so that is why I have got confused. So, maybe apologize for that. Sorry.
I completely go by what the advocate says. I don't
Sorry,
doubt anything.
I'm very sorry. For that, my lord.
Lord, it is above knee, my lord.
12, para 12 it says,
Para 14
in the light of the aforesaid decisions, we find it extremely difficult to uphold the decision of the High Court and the tribunal based on the finding that the loss of the appellant's earning capacity as a result of the amputation of his left leg was only 50%. Appellant used to earn his livelihood as a cart puller. The tribunal has found that at the time of the accident, his age was 55 years. At that time, it would be impossible for the appellant to find any job.
Next is this.
But the computation of compensation payable to a victim of motor accident who suffered some serious permanent disability is so and so. Any scaling down of the compensation should require something more tangible than a hypothetical conjuncture. As high as 100%, but in no case it would be less than 90%. Look for some judgment on this.
The schedule injury 50%.
That's what, but he's asking for 90%.
Why, my lord? Why it is below knee, above knee? If it is above
No,
knee,
that's what,
there
even
is
in,
nothing of
no,
having
no,
processes
in
and
other cases, I have also passed the same order. That's why now I will not pass any order. I'll give you some other day. Come up with some judgment. This is matter, strike it off. This is matter on 20th of November.
42.
Lord, I'm very sorry. Sorry,
No,
my
it's
lord.
okay. It's okay. Yes, yes.
Shashidhar.
Respondent number 3 in this.
Yes.
My lord, case of death, my lord. Date of accident, my lord, the 16.
On what ground, where the enhancement is required?
Personal expenses, my lord, deducted 50% instead of 1/3 claimed by wife and
Wife
son.
and major children is that is
In your,
what.
is, wherever it's wife, I'm taking 1/3 only.
Please, ma'am.
Then, my lord, future prospects, my lord, granted
1 minute. What is the, which year is the accident?
accident, my lord, 16/10/2019,
19. How much was taken?
14,000 is
Correct. Then what is the age?
age, my lord, 50 years.
Then
As
what is,
25% future prospect.
As per PM report, it's 50 years, ma'am.
future
But they have,
prospect?
other than PM report, they have not produced any
In your
other card.
PM report is there with regard to the 25%.
Please.
1/3 has to be, it has deducted 50%.
Please. Then, my lord, compensation granted under conventional rates.
At that time, anyhow, we will relook into all that. It comes to 11,667 into 12. What's the multiplier?
13 minutes.
Into 13. It's coming to 18,20,052. How many are the claimants?
4.
4. 4 into 44. 1,76,000, 36,000, 10,000. It's coming to 20,42,052.
Medical expenses, my lord,
Are
granted.
there?
As per
Medical expenses.
54,655.
54,655. It's coming to 20,96,707 against 30,10,855. Agreed with the award passed in NBC number 206 of 2020 dated 31st August 2023. The claimant is before this court seeking enhancement of the claimants are before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees
13,10,855.
claim petition.
In claim petition, the claimant 46 lakh.
Seeking 46
50,000.
lakhs for the injuries sustained by the claimant. The tribunal has
death of-
awarded for the death of the deceased. The tribunal has awarded the compensation as per the table given below at paragraph number 29. Land counsel appearing for the claimant submits that when the wife is a dependent, as if he's a bachelor, the court had deducted 50%. Future prospects were not considered. Further, it is submitted that even in the conventional heads also, the amount that is awarded is not reasonable. Land counsel appearing for the respondent insurance company submits that the court has granted a just and reasonable compensation. Next, having also the claimant, considering that this accident had taken place in the year 2019, the income is taken at 14,000, and as he's aged 50 years as per the PM report, postmortem report, the 1/3, the 25% future prospects have to be considered. It comes to 3,500. Then his income is 17,500. As the wife is the dependent, the 1/3 has to be deducted. That comes to 5,833. Then the contribution to the family would be 11,667. 11,667 into 12 into 13 is 18,20,052. Under the head of consortium, 4 into 44, 1,76,000. Funeral expenses, 36,000. In the light of the law laid down in Mekala, 10,000. Further, the court had granted medical expenses of 54,655. Altogether, the claimant is entitled for an amount of rupees 20,96,707. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 13,10,855 to 20,96,707. The enhanced amount shall carry 6% interest. Yes.
43, one of Sitaram.
My lord, I am for the respondent number 3, my lord.
I appear for the appellant in this matter. Appeal of the insurance company was challenging our liability on a simple ground, my lords, that I have issued only a standalone own damage policy. Some other company has issued the third party policy. Policy is there. They have not been made a party. Hence, this appeal requires to be allowed. Matter has to be remanded so that they implement the appropriate.
Because the
You are for the claimant.
please.
So we will allow the appeal and remand the matter. Now they are already on record.
No, they are not already on.
No,
They have not been included even in this appeal.
They were not. Now they are. D. Vijay Kumar appears for the.
No, my lord, there is no liability on us because our liability is already satisfied. Our liability 50% is already satisfied. We are not fighting it.
There are two vehicles involved, my lord.
Allegation against us.
So now the dispute is remaining 50%.
Yes.
Yes, my lord.
Who is the
That
owner?
will be the owner of the vehicle and insurance company.
Lombard, they ought to have implemented them in this.
Why should I implement in this appeal, my lords? It has to be done
Because-
before the trial court. They have to be given an opportunity.
Please come. Yes. Agreed with the award passed on MVC number 3154 of 2022, dated 3rd April 2024. The insurance company is before this court. The claim petition is filed against the Cholamandala General
no.
Insurance Company.
Royal Sundaram. There are two
Royal
vehicles
Sundaram.
involved.
So that also.
But our liability we are satisfied. 50% of liability we are satisfied. No dispute among us.
Mr. Vijay Kumar, from now onwards, I will not hear you online. You should come to the court. Cholamandala against the respondent number 2 before the tribunal was Cholamandala MS General Insurance Company, and the fourth respondent is Royal Sundaram General Insurance Company. It is a case of the claimants that on 30/5/2022 at about 9 a.m., the claimant is a pedestrian on the extreme left side of the ring road and was carefully observing the vehicle movements and crossing the road. At that time, suddenly the driver of the goods auto came from Gorugunta Palya side in a rash and negligent manner, endangering to human life without observing any of the rules. Dashed the claimant, due to which he fell on the right side of the road. The wheels of the said goods auto ran on the right leg. At the same time, the rider of the motorcycle came in a rash and negligent manner, endangering the human life without observing any of the traffic signals, due to which the petitioner sustained grievous injuries. The goods auto is the insured by
Cholamandalam.
Cholamandala General Insurance, and the two-wheeler is insured by
ICICI Lombard for third party risk, Royal Sundaram for own damage standalone policy.
the two-wheeler is insured by the ICICI Lombard for third-party insurance, and by Royal Sundaram. You appear for Royal Sundaram. It is, what is that policy?
Standalone own damage policy.
The Royal Sundaram standalone damage policy. The tribunal, by order impugned, had fixed the liability on the tribunal has held that there is a rash and negligent driving on the part of the driver of the goods auto as well on the part of the rider, and had fixed the liability on the Cholamandala MS General Insurance and as well as Royal Sundaram General Insurance Company Limited, who have insured the auto and the bike. Now the Royal Sundaram General Insurance is before this court, stating that as far as the bike is concerned, it was only own damage. What is it called?
Standalone own damage policy.
Standalone own damage policy, and they have not insured the vehicle with regard to the third party claims. In that case, the appellant insurance company is not liable to pay the compensation. If at all any compensation that has to be paid, that has to be the ICICI Lombard Insurance Company, and the claimants have not made the said insurance company as a party as respondents to as not made a party to the claim petition. It is submitted that the tribunal has failed to take into consideration all these aspects, and particularly the aspect that the insurance company has the appellant insurance company has no liability. Next para. Land counsel appearing for the claimant submits that to this writ petition, to this appeal, the insurance company has not made the insurance company ought to have made ICICI Lombard as a party to this appeal, and without making them a party, they have filed this appeal. Land counsel appearing for the insurer of the goods auto submits that their 50% of the liability they have already satisfied, and they have not they're satisfied, and they have not questioned the same. Next para. The undisputed facts in this case are the appellant insurance company has insured the car, has insured the bike, that is for the standalone own damage policy. And admittedly, there is a third party insurance by another company, that another insurance company, that is ICICI Lombard. Claimant insurance company, the respondents for the best reasons known to the claimants for the best reasons known to them have not made that insurance company as a party to the claim petition, as a party before the MSCT. When there is the insurance company is bound by the terms and conditions, the parties are bound by the terms and conditions of the policy. When the insurance company has not insured the vehicle for the third party liability, the tribunal ought not to have fixed the liability on the appellant insurance company. In that view of the matter, the order, the appeal, the order of the tribunal is set aside as far as the liability of the appellant insurance company is concerned, and the matter is remanded, giving an opportunity to the claimants to implead the ICICI Lombard Insurance Company. Accordingly, the appeal of the insurance company is allowed. And the amount in deposit, the insurance company is at liberty to withdraw. The tribunal, the claimant shall appear before the tribunal without further notice on 1st of December, and within 2 months from 1st of December, the tribunal shall dispose of the matter.
On submission, appeal against R3 may be dismissed.
Appeal against
R3.
Why?
R3 is not in this. We have not challenged liability.
Yes, nobody has challenged liability. We have satisfied. We have already satisfied the award.
So why should it be dismissed?
Because they have made a party. Again notice will be issued from the tribunal.
I said the appeal, the order is set aside as far as the liability of there is concerned.
Please, madam. Interest. Yes, madam.
Yes.
Kindly say it, because again there should not be any confusion before the tribunal.
Yes.
44.
Manoj, one request. Amount in deposit to be transmitted to MSCT for dispersal, Manoj, because I have made deposit.
Either ways, the amount in deposit shall be forthwith transferred to the tribunal, and the insurance company is at liberty to withdraw. Yes, 44?
44, Sunkapur.
Case of injury, my lord.
Yes.
Table is at page number 15, my lord.
Hmm.
3 fractures. my
What
lord.
are the injuries?
Injuries, fracture of right leg, fracture of right hip and right knee, my lord.
Yes, Mr. Betsu, 70,000? No, 60,000? Yes, pain and suffering, 60,000.
50,000 given already.
Another 10,000. Another 10,000, 60,000. Yes. Medical expenses.
As it is, 2 lakh 80.
With regard to disability, my lord.
1 minute. Incidental expenses, how many days he was there?
40 days, my lord.
Huh?
40 days. 40.
40,000. Then loss of income during later period.
Not awarded. my lord.
Which year is the accident?
2019, my lord.
It comes to 56,000 for 4 months. Then, yes, now loss of future income. What is the evidence of the doctor?
My lord, doctor, page number 12, my lord.
What did he say?
He said, my lord, 30% with regard to right hip and 30% with regard to right knee, my lord.
30% with regard to?
With regard to right hip and 30% with regard to right knee.
Hmm.
The tribunal has taken it 13%, my lord. That is lower side.
In this case, my lord,
Treated doctor is assessed to the disability.
30% to the limb, my lord, particular limb, and tribunal taken rightly 13% whole body.
It has taken?
13% whole body,
No, it
1
is-
3.
How can it be a limb disability? Limb disability is 1/3 or 1/4?
1/3, my lord.
It's coming to 20%.
20%.
No, my lord.
If it is 1/3.
13%. I have got the deposition of doctor. He has said 30% disability.
30% to the hip, 30% to the knee. Put together, it
No,
is
my lord,
60%.
in the cross examination he has admitted. In the cross examination he has admitted.
Take that.
I do not remember about the avocation of the petitioner. It is false to suggest that he do not have difficulty in using his leg and hip. It is false to suggest that due to fact that there will be a tenderness and swelling in the hip and leg. I have given 30% disability to hip and limb.
Show
That
it to
is
him.
confusion by oversight. It has been done. Cross examination he has admitted. On the basis of admission, tribunal taken 1/3 of that.
Yes.
Mark ಮಾಡಿದ್ದೀನಿ ನೋಡಿ. And apart from that, my lord, in the cross examination, he has clearly stated, my lord, he has not furnished the X-ray reports and everything. And 1/3 of the leg.
13, my lord, exhibit P13. The treated doctor has given as 60%, 30% and 30%.
That is also given by him only. To the doctor, no, you examined him. Yes. Income is taken, right?
Not
14,000?
Income less taken, my lord.
How much it is
2019,
taken?
9,000 taken, it should be 14,000.
Yes, so loss of future income, 14,000 into 12, what is the multiplier?
For 11,
11, my lord.
55 years.
It comes to 1,84,800. Then loss of amenities,
Amenities,
10,000 given, my lord.
another 20.
future medical expenses. Future medical expenses.
What is the evidence of the doctor?
He has not said anything.
Did he say many operations required?
But there
No,
is
my lord.
3 injuries, my lord. Fracture of leg.
Every injury doesn't require a future operation. You have to elicit from the doctor. If he says, even if he doesn't specify the amount, we will grant some amount. But he didn't say that future
Plastic surgery
operations.
is done, my lord.
Huh?
plastic surgery is done, my lord.
Already done plastic surgery.
For that,
26
you are getting the,
It is
Further
in the final
management
bill.
at the time of discharge, my lord. The 20, page number 12, my lord. The
No.
petitioner got discharged from hospital on 23 and patient transferred to plastic surgery for further management at the time of discharge.
hmm? It comes to 6,60,800 against 5,04,440. Come.
One more submission, my lord. Before the tribunal, 9% interest was given, and by in filing in this appeal, 537 days delay, interest is waived off.
Future amount 6%. You have not for any appeal.
The-
So
the
for the
delay period-
enhanced amount 6, delay period, they are not entered.
Yes, ma'am.
Agreed whether in all these matters, look at the order sheet, whether delay is unknown, if I don't tell or not. Agreed whether award passed in MVC number 721 of 2019, dated 30/11/2022. The claimants or before claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 15. And counsel appearing for the claimant submits that when the claimant has sustained grievous injuries under the head of pain and suffering, loss of amenities, and the court has not granted a reasonable amount, it is submitted that when he was in hospital for 40 days, court has only granted 10,000 under the head of incidental expenses. Further, no amount is granted on the head of loss of income during the later period. It is submitted that so when it comes to the loss of future, when it comes to the income, court court had taken the disability at 10%. When the doctor's evidence is that he had sustained 30% disability to the hip and 30% disability to the right knee, it is submitted that on all counts, the compensation needs to be enhanced. Next para. Then counsel appearing for the respondent insurance company submits that. In the evidence of the doctor, he has categorically stated that the disability to the limb and to the hip is 30%, and the court had taken 1/3 of it at 10%, and there are no grounds to interfere with the same. Even under the other heads also, the amount of compensation that is awarded is just and reasonable. Next, having heard so and so, but is submitted on record. Considering the grievous injuries to that are sustained, this court is granting an amount of rupees 60,000. Medical expenses, no interference is called for. He was in hospital for 40 days. Incidental expenses 40,000. Coming to the later period, as per the chart, this accident had taken place in the year 2019. 14,000 into 4, 56,000. Loss of future income, as rightly argued by the learned counsel for the insurance company. The doctor has deposed that to the hip and the limb, to the knee, it is 30%. Hence, 10% was rightly taken. Hence, 14,000 into 12 into 11 into 10 by 100 is 1,84,800. Loss of amenities, this court is granting 30,000. Legal expenses in the light of the laws of insert. Altogether, the claimant is entitled for an amount of rupees 6,60,800. Accordingly, the appeal is partly allowed, enhancing the compensation from 5,04,440 to 6,60,800. The enhanced amount shall carry 6% interest. This court has condoned the delay by order dated so and so on condition that they are not entitled to the interest for the delayed period of so and so. Hence, they are not entitled. Yes.
45.
Entire amount can be released. Entire amount can.
The amount shall be, in all these cases of injuries, it will be released. Only in cases of death only, I am not passing any such order. Yes.
Case of injury, my lord. The table, my lord, in line number, page number, my lord, 26 of the judgment. Running page number 34, my lord.
What are these judgments?
My lordship.
Some judgment is here for what?
This appeal is pertains to my lord MEC number 1254.
No, some judgment of the Supreme Court, for what purpose?
I had cited minutes on the last occasion, minutes,
Hmm.
for the other bench minutes. I had cited that judgment.
So let's see.
Please.
Where is the table?
Table on page number 34, my lord, running page number.
Yes. What are the injuries?
Lord, injury, my lordship, comminuted fracture of right femur, distal 1/3 fracture of left tibia, comminuted fracture of left clemicum, hemotic anemia, my lordship. This is four, my lord, four grievous injuries. My lord, he is a driver by profession.
So 4 injuries.
Please.
40. Another 10,000.
No, my lord, 4 fractures, my lord.
Yes. First fracture 40.
Please, my lordship.
3.
All are grievous in nature, my lordship.
70. Yes, next. Medical expenses as it is.
Please.
He was inpatient for 9 days, minutes.
3,20,000. How much is granted?
27,000 is granted minutes towards food, nourishment and incidental expenses.
We'll leave it there. 27,000. Then future medical expenses, I think already granted.
No, my lord, as per the evidence of CW1, my lord, 1 lakh, my lord, the court has awarded only, my lord, 40,000. my lord.
How many?
He was 10 days inpatient.
No, that,
Please.
forget about it.
Please.
Why the doctor said it requires how many operations?
For
are
removal of the
required?
implants, my lord.
How many operations?
2 operations, my lord.
Yes, if for one we are granting 40. If the evidence of the doctor is 2, we'll grant 80.
Kindly see minutes, the.
Look at it, look at the doctor's evidence. What did he say?
Please. ಯಾವ ಪ್ಯಾರಾದಲ್ಲಿ ಇದೆ ಇದು? ಮಲ್ಲಿಕಾರ್ಜುನ್ ಯಾವ ಪ್ಯಾರಾ ಡಾಕ್ಟರ್ಸ್? Kindly see minutes, para 24 minutes, future medical expenses. As such, CW advised the petitioner for one more surgery, that is implant removal, approximate cost of
Which
1
year is
lakh.
this accident?
2021, my lordship. Please.
But except the above said evidence, no estimation report produced by the doctor while his evidence.
What did he say?
There is no estimation, but except the above said evidence, no estimation report produced by the doctor.
What is the evidence of the doctor?
Doctor, approximately cost of the minutes removal of the implant, 1 lakh he
Two
says.
operations, that is what I want to
No,
know.
minutes, it is only 1 minute. As such, CW advised the petitioner for one more surgery, that is implant removal.
40,000 is reasonable. Yes.
Regarding disability, my lord.
1 minute. Loss of earning during the later period income,
Please.
75,000. Then loss of future income. What is the evidence?
As per the future media, as per the evidence of the CW1, Lord, 1 lakh, Lord, approximately 1 lakhs, court has awarded granted only 40,000.
So for that 40 only, because whatever, there should be some basis for grant. One operation, why you require 1 lakh?
He is a driver by profession, auto driver.
For a driver, different operation won't be there. Same, for removing the implants, driver, mason, everybody same operation. So please come to loss of future income. What is the evidence of doctor?
Evidence, my lordship, as per the evidence of the doctor, my lord, 48%, my lord, 48% left lower limb, 43%, my lord, right lower limb, my lordship. So it will come, my lord, 93%. Court has taken, my lord, 31%, 1/3, my lordship.
Rightly taken.
Future prospects have to be added, my lord, in this case.
It's not granted?
No, my lordship.
Yes, we'll grant future prospects. He's entitled.
Minutes,
30% for disability is entitled.
It's according to me, minutes, he has not surrendered his driving license, minutes, to show that.
That is this
Be that as it
argument,
may be, minutes,
this
31% is taken, minutes, which is just and reasonable. Therefore, minutes, future prospect, adding a future prospect.
He is coming to the court, giving evidence and all. If a person has 30% disability, he might be doing, he will not be do the work as per his
Yes,
capacity.
that efficiency may not be there, but still, minutes, he would continue to do that job with some difficulty. Therefore, minutes, I had relied on the judgment, minutes, which.
That I will consider and pass.
Please.
2021,
15%.
That is rightly taken, minutes.
Rightly income taken.
50,000.
Yes.
So future.
All heads are, minutes, appropriately granted.
Future prospects at 40%. What is his age?
Age 37, 34 years, my lordship. But trial court,
37 minutes.
but trial added 37, taken the 37, by
The
multiplying
finding, minutes, of the
15%.
tribunal is 37, minutes. That is
37.
rightly taken.
So anyhow, even if whatever 34 or 37, but as far as future prospects, it doesn't make any difference.
Yes, yes.
21,000 into 12 into what is the
31%, my lordship.
31%? What is the
Amount,
multiplier?
Multiplier 15, my lord.
15 into 31.
Please.
8,37,000 is now granted, my lords.
Huh?
8,37,000 is now granted.
That's what I'm calculating into 12, into 15, into 31, divided by 100. It comes to 11,71,800. Then loss of amenities, what is granted?
Loss of amenities, my lord, only.
30,000 is granted.
Not for 30% disability. What we are granting is for much lesser also. So another 20,000.
Laid up period, my lord. He was.
I've already granted
Please.
75,000.
Please.
4 months, my lords, is already granted by the
I've
tribunal.
granted one more
He's
month.
inpatient only for 9 days.
But, looking at all this, the disability and all, it takes some time for him.
Lordship, kindly, my lords, consider my, my lords.
That I will consider.
Yes.
I will look at the judgment. Once I'll make the calculation. It's coming to 17,73,530 against 13,83,730. Yes, no, let's see the judgment now.
Please. This case,
Hmm.
it's a case of amputation, my lords. The injured was a, my lords, businessman, was also filing IT returns. Lordship may kindly see, my lords, the disability is taken 50%
Hmm.
to the whole body. And, my lords, para 9, my lords, request to, my lords, come over to para 9.
Yes, please read.
However, since just compensation is granted, we do not find any reason to award compensation for loss of future prospects. It is clear that the claimant, though has suffered disability which has been determined to be 50%, there is no difficulty in continuing the business, and the claimant has also been fitted with a prosthetic leg which ensures his mobility and continuance of the business. The 40% enhancement in the annual income for taking into account the future prospects is found to be improper, especially in the context of 50% disability, having been reckoned for the purpose of loss of.
This judgment of the apex court is basing on the facts of a particular case.
Yes, no,
One.
sir. What I
There
am.
is no ratio laid down.
Yes,
Now, general rule, what we are following is about 20% disability, the courts are granting the future prospects.
Yes.
Why we should, why this judgment without considering the earlier judgments is not known. Let's just settle that. That's what is being followed.
Yes, this is in the facts of Mars. I am just Mars observing Mars.
I'll record that you have contest, you have, that's your contention. Please come. Agreed with award passed. This is MBC number?
MBC number
PC number
1254, my lord.
1260.
1254 of 21, my lord.
Agreed with award passed in 1254/2021, dated 2nd March 2024. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at 37.
Please, my lord.
37, yes.
Please.
At 37. The claim petition is filed seeking compensation of
Compensation rupees, my lord, 25 lakhs, my lord.
25 lakhs for the
Please.
injuries sustained by the claimant. Where are the injuries discussed?
Injuries, my lord, page number, my lord. Page number, my lord, 28, running page number, my lord.
28.
Please. Para number 28, my lord.
As per the claimant, as per the evidence, the petitioner suffered, the appellant claimant has suffered commuted supracondylar fracture of right femur, distal 1/3 fracture of left tibia, commute fracture of left calcaneum, hemolytic anemia. He was operated on 18/8/2021 with one RF with LCP and 10 nail to right femur, 2 CRIF with ILIM nailing to left tibia. Fracture calcaneum treated conservatively. and he was discharged on 25/8/2021. After as per the doctor, after when they examined the appellant, they found that there is the complaint of the claimant is limp, both lower limbs, pain in left leg, ankle, foot. Also complained of difficulty in walking, sitting on floor, sitting on cross-legged climbing stairs. X-ray shows small united fracture of right femur, small united fracture of the left calcaneum. The doctor has opined that disability of the right lower limb is 45% disability, and the left lower limb is 48%, and the whole body disability is 31%. In support of his chief examination, he has also produced the documents as case sheet, OPD card, 3 X-ray film, and disability assessment chart. The tribunal had taken the disability at 31%. Lead counsel appearing for the claimant submits that the future prospects were not awarded by the tribunal, and the loss of income that is considered is only 4 months, which is on the lower side. And then considering the disability of 31%, the loss of amenities that is granted by the court is not a reasonable compensation. It is submitted that on the head of pain and suffering, and on all the counts, the compensation needs to be enhanced. Next part. When counsel appearing for the insurance company submits that the claimant is not entitled for future prospects, it is submitted that there is no evidence on record to show that the appellant, who is a driver has surrendered his driving license, and he is no more driving the vehicle. There is no evidence on record to show that the petitioner, the claimant has was not able to drive the vehicle. In these circumstances, question of granting future prospects would not arise. He had relied on a judgment of the apex court in Anup Maheshwari versus Oriental Insurance Company Limited and others, arising out of civil appeal number 12098 or 98 to 12099 of 2024. It is submitted that in that case, the disability was taken at 50%, but the future prospects were not considered. The Honorable Apex Court at paragraph number 9 and he has relied on paragraph number 9, extract paragraph number 9. It is submitted that in those circumstances, Apex Court has refused to grant future prospects, and it will apply to the facts of this case and is not entitled for any future prospects. It is submitted that on all other counts, the amount of compensation that is awarded is just and reasonable. Anything else to be added?
No, that's it.
Having heard the counsels on either side, where is the material on record? The first submission of the counsel for the petitioner, appellant, claimant is that the future prospects are not considered. It is a submission of the insurance company that he is not entitled for the future prospects, as he has not placed any evidence on record to show that he has quit driving, and he is not in a position to continue the earlier occupation. In those circumstances, the judgment referred to supra in Anup Maheshwari's case applies to the facts of the case. This court is not able to appreciate the submission that is made on behalf of the insurance company. The general rule, as per the settled law, wherever the disability is above 20%, the courts are considering the future prospects. In the facts and circumstances of that case, the Honorable Apex Court has not granted future prospects, and that cannot be considered as a ratio laid down by the Apex Court, and that cannot be applied to the facts and circumstances of this case. The claimant is a driver. He has suffered 48% plus 93% disability to the 48% to
48% to the right lower limb.
Right lower limb, and 43%
48 left lower limb, my lordship.
And left lower limb. Altogether, he has suffered 93% disability to the limb. And he is working as a driver. A disability of 93% to the limb will have a, will without without any doubt, it will have an impact on a person's life, his efficiency, his mobility. Just because the driving license is not surrendered, that cannot be a reason for the court to not to grant the future prospects. Hence, in this view of the matter, this court is of view that the petitioner, the appellant, is entitled for the future prospects. Hence, under the head of loss of future income, 15,000 plus 40,000 future prospects would come to 6,000. That is 21,000 into 12 into 15 into 31 by 100 is 11,71,800. And the head of pain and suffering, the tribunal has granted 60,000 and this court is granting 70,000. No interference is called for in medical expenses and incidental expenses and future medical expenses. Coming to the loss of income during the later period, this court is inclined to grant for 5 months 15,000 into 5, 75,000. Coming to the amenities, considering the disability of 31% to the limb, 31% to the whole body, this court is granting 50,000. In the light of the law laid down in so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 70,73,000, 73,530, 536 or 530. You calculate.
513 minutes.
513.
513. 17,73,513 minutes.
513. You calculate it again. Accordingly, appeal is partly allowed. Enhancement from 13,83,732. So and so. The enhanced amount shall carry 6% interest.
Enhanced amount may be released.
Anyway, that will be condoned with it has to be condoned or condoned. Then it's okay.
Enhanced
Yes,
amount
thanks.
may be released.
Yes,
Enhanced amount may be released.
Huh?
Enhanced amount may be released. Entire amount may be released.
That will be there in all these cases. You don't have to ask it specifically. Yes. Yes.
46, Ashokian Patil.
Pay for the respondent claimant in the next case.
You're on what ground?
Lords,
For
my
both
case is for
appeals are there.
enhancement. Yes.
May I request this matter to be taken up next week, minutes. I'll file wakalat in the connected matter, minutes. I have not yet filed. And TCR would be required, minutes.
Yes, admit post.
It has come, my lords. TCR is not put up with the file. I mean, with the file.
Post for final hearing. It's already
It is
for
in the
final
final
hearing.
hearing.
TCR list this matter after the TCR is received. Not put up.
Next week it could be listed, ma'am.
History is directed to put up the TCR. List this matter on December 10th.
Please.
In my case, Lords, there is delay of 160 days, 168 days. That may be condoned.
I number in 46.1. I number 1 of 25 is filed to condone the delay of 168 days, condoned on condition.
Please.
Yes.
47, Vijay Kumar T. Vijay Kumar.
Respondent number 1, my lord.
He was asking for time. List this matter in the month of December. Don't give the date. In the month of January, not December. Don't give the date. It's 48.
48, Dheeraj Eki.
Second respondent.
And they're seeking adjournment.
Why?
Senior.
What is this case? This is matter in the month of January. Nobody, whoever is not ready, then January. This is matter in the month of January. Yes, 49.
49, Janardhan Reddy.
Lordship, sought for remand the matter for fresh consideration on the grounds that we have taken defense that the liability aspects, my lordship. When the matter was posted for respondent evidence, we have filed an IA for summoning the MLC records from the concerned hospital. The petitioner also filed objections. Then matter was posted for order for IA 8. Without passing the orders on 8, the judgment was passed by the tribunal, my lordship.
We'll set aside and.
But they have not reduced any evidence before the tribunal, my lord.
That's why I have taken the application, summoned the application.
Still not.
There was a
put up
delay
their
is there.
appearance and
adduce the evidence. They are not
No, when
produced.
they filed the IA, court has to consider the IA. MLC is important. I mean, in
Also
support
produce the
of their
order sheet
case, what
also.
is that?
Order sheet, my lordship. Order sheet also is.
Use that. Please come. Agreed with the award passed in MBC number 413 of 2023, dated 11th March 2025. The insurance company is before this court. It is submitted with the land counsel that the insurance company has filed I number 8 for summoning the
Medical records. Medical records.
for summoning the medical records. While that application is pending, the tribunal, without passing any orders on the said IA, had disposed of the main MBC, claim petition itself. It is submitted that the tribunal ought to have given an opportunity to the insurance company to adduce the evidence when they are disputing the accident. Next para, and counsel appearing for the, and in the same para, it is submitted that hence the order, the award may be set aside. The matter may be remanded for fresh consideration before the MSCT. Next para, and counsel appearing for the respondent claimant submits that in spite of giving enough opportunity, the insurance company has not adduced the evidence which compel the court to pass the order. Hence, in these circumstances, the remand is not required. Next para, having heard the consensus. From the docket proceedings, it appears that
21 February
on 28, the order dated 28/2/2025 discloses that the case is called out. The counsel for petitioner filed objections to IA number 8, heard, posted for order, call on by 7/3/2025. On 7/3/2025, it says that case is called out, order not ready, call on for order by 11/3/2025. Then, when the matter came up on 11/3, the court has passed the order in the main claim petition itself. These circumstances, this court deems it appropriate to set aside the award dated so and so, and demand the matter for consideration before to the MSCT. The part further notice from the court shall appear before the court on 9th of December, and the court shall consider the same and pass appropriate orders within 6 months from the date of 6 months from the date as at 10th, which is the date as at from 9/12. The amount in deposit shall be transferred to the trial court and shall be kept in a fixed deposit.
50, V. Pradeep.
Still in the office objection stage. Connected appeal filed by the claimant, still in the office objection stage.
What are the office objections? What is the matter about?
I'm for the appellate in connected matter. Entire cast title to be filed. Entire cast title to be filed in condonation of delay application.
Yes, this is the 50.1. The appellant shall comply with the office objections within 10 days, or else the appeal shall stand dismissed without further reference to the court. Once the office objections are complied with, list these matters. Yes. Next.
List number 2, serial number 1.
Yes, Pramod.
B. Pramod.
Appellant. We have taken steps.
What steps?
We have to process money.
What is the purpose of taking it? The petitioner shall shall come up with an appropriate application for substituted service of notice. Second respondent is who?
Coco
Then why is it being adjourned when the insurance company is here? First respondent is served.
Is dispensed with.
Coco DHL General Insurance Company, who appears? Coco. No, it's Coco. CO.
That is the wrong. ACKO. ACKO.
No, let me look at the cause title before the trial court. It says The branch manager, COCO, DHFL General Insurance,
Then we are not aware.
IDBI Bank, Rajaji Nagar, Bangalore.
That company is also there, I don't know. Whether that company is also there, I don't know. I don't know, my lord.
The respondent is at liberty, the petition shall file an application for substituted service. Shall file an application for substituted service within 10 days, or else the appeal shall stand dismissed against respondent number 2. Yes, 2.
Appear for appellant. Filing memo for dispensation notice for R2.
2 R2.
R2.
A memo is
R1
filed
is
seeking
in.
dispensation of notice to R2, dispensed with. Ready?
Well, it is a case of death, short point, my lord. Income taken by the court below 12,000 instead of 14,000.
That's the only thing.
And also under conventional aids, my lord.
Huh?
Conventional aids.
That we will see.
Shall I
So
give-
which year is the accident?
2000, my lord.
Earlier matter.
2019 accident, my lord.
Lordship, for reference,
You shown it to him?
no. He wants to argue the matter, that's why.
Why you want to argue?
No, in this case, the decision.
No, your only ground is with regard to the income and the
Please.
conventional heads. So why you want to argue 88,000 conventional two people,
Please.
88,000, where is 36,000 Pradeep?
That is estate.
Where is it?
16,500, 16,500, bifurcated and estate, 16,500.
16 is how much?
32.
32.
33.
We are granting 36.
33, my lord.
33, but we are granting 36. So
Needs to be corrected.
make it 36.
Please, please.
So how much we have to add? 16,000, 36.
Another 3,000 has
37. How is it? 16 plus 16 is?
32, my lord.
32 plus 500, 33. So another 3,000 to be added to
36.
this total.
Please.
How much is the total? 24,000, 21,000, 24 lakhs, 21,504. So it's 24 lakhs, 24,000. It's 504. Please come. The court had taken how much?
12,000.
12,000.
12,000. One more calculation is required, 12,000.
Lord.
Future prospects at
40%.
40% comes to that. Whenever you make the calculation, please do that, because for dictation it is easy.
Please. I made a calculation also, my lord. It is in middle,
40.
in the middle.
Divided by 100. It comes to 4,800. That is 16,800. How much to be deducted?
My lord, 50 is a bachelor, my lord.
Oh, is a bachelor.
Please.
It comes to 8,400. 8,400 into 12
into 12, my lordship. Multiplier taken 12.
17.
Sorry,
17.
17 adapted.
We'll apply 12.
12 months.
It comes to, it is coming to 17 lakh 13,000.
17 lakhs, 13,600.
But you said it is 19 lakhs 99,000.
No, my lord. If 12,000 consider, that will come, my lord.
Income taken.
Lordship
It
has
has
to
to
take
be-
14,000.
Oh, that's it.
14,000.
MSCT has considered 12,000. 5,600. 5,600.
Then it will be 19,600.
19,600 divided by 2. 9,800 into 12 into
Is
17.
9,800
Into 12 into 17.
into 12
19 lakhs, 99,200.
into 12 into 17. Yes. Agreed with the award passed in.
There is a delay, my lord, delay of 546 days, my
It
lord.
is already condoned.
No, my lord, not yet condoned.
It has to be condoned.
Please.
It's there. I number 1 of 24 is filed to condone the delay of 546, condoned on condition. Agreed with the award passed in MVC number 4563 of 2019, dated 17 June 2022. The claimant is before this court. The claimants are before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 15. Land counsel appearing for the claimant submits that this accident had taken place in the year 2019, but the court had taken the income at 12,000, which is on the lower side. It is submitted that under the conventional heads also, the amount that is awarded with the tribunal is not just and reasonable. Next paragraph. Then counsel appearing for the insurance company submit that the tribunal has granted a just and reasonable compensation. Next, having heard the counsel on the said there is the material on record. The accident had taken place in the year 2019. Hence, this court is taking 14,000 as income. Future prospects at 40% would come to 5,600. It is 19,600. As he is a bachelor, 50% has to be deducted towards the personal expenses. It comes to 99,800 into 12 into 17. Under the head of loss of dependency, 19,99,200. As the claimants are two in number, towards loss of consortium, 88,000. Medical expenses as awarded by the court, 3,01,304. This court is not interfering. Funeral expenses, 36,000. In the light of the law laid down, 10 also not added.
Not.
In the light, so 10,000. Altogether, the claimant is entitled for an amount of rupees
24 lakhs 34,000 34,504.
34,504. Accordingly, the appeal is partly allowed, enhancing the compensation from 21,24,904 to 24,34,504. The enhanced amount shall carry 6%.
Not entitled interest for delay period.
Now this court has condoned the delay of 546 days on condition that they are not entitled for interest. Hence, the claimants are not entitled for interest for 546 days. This next.
For 3, Jagdish.
Appear for the appellant. R2 is the Reliance General Insurance Company. Reliance General Insurance Company.
This Pradeep appears for Reliance.
Pradeep.
Yes, Pradeep.
Please.
Mr. Pradeep is directed to take notice on behalf of the insurance company. It's a case of death or injury.
Injury case, perhaps.
IA number 1 of 24 is filed to condone the delay of 205 days in filing. Condone, admit final hearing this year. Next 4.
Please.
Postal authority saying lots unclaimed.
4.
Where is that?
In the cause list it listed.
Insufficient.
No. It
In one
says-
case, for both are for one person only.
No, but we have to take it independently.
In one-
Independent cases, one case it can claim, we will say 4.1, notice to R1.
For the very
Returned with
same
the postal
person.
share unclaimed amounts to deemed service of notice. You have to take it in 4.
For the very same person only.
That I understand. There are 2 different appeals. It requires that the
I'll-
notice
I'll
has to
take
go.
steps. I'll take
Yes,
steps.
the 4 for taking steps,
Yes, ma'am.
a week's time.
In the meanwhile, records is required. It will
I call for, registry is directed to call for the records.
I do.
Yes, fine. List after service notice.
3 is ICICI.
Yes,
So 6, Jagdish.
a week's time default order.
Minutes, to memo for dispensation of notice to R1.
Memo is filed seeking dispensation of
Maybe
notice to
disposed of
R1.
minutes.
Dispensed with.
Global another 15 to 20.
1 minute. IA 1 of 24 is filed to condone the delay of 147 condoned on condition. Yes.
Because the whole body disability assessed is 4%.
Hmm.
Globally,
That has also
20,000.
been taken. A 30-year-old person.
20,000
I
maybe.
think another 20,000 would suffice the
Like, shall I pass a judicial order or say?
judicial order is by considering the facts.
Yes. With interest or without interest? With interest.
With interest.
The
That's para 20.
agreed with the about passed in MVC number
Service.
880.
881 of 2022 dated 19/12/2023. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. Under which head we will increase?
Let's
Globally.
Huh?
Globally.
No, somewhere we have to say, I can't say. How many days he was in
She-
hospital?
9 days she was in hospital.
10 days, medical expenses, pain and suffering, how many injuries?
45,000. Not the fresh injury to the right foot, minutes and.
Here,
20,000 on that
here
count. On that.
it is as per the table given below at page 23. Land counsel appearing for the claimant submits that the tribunal has not granted a just and reasonable compensation. And at all the heads, the compensation needs to be enhanced. Land counsel appearing for the respondent submits that the court has granted a reasonable compensation and no enhancement is called for. Having heard the counsels on either side, so the court, under the head of medical expenses, as per the evidence, has granted a reasonable amount. Coming to the attendant charges, for the hospitalization of 10 days, the court has granted 10,000. And towards loss of amenities, for the disability of 4%, Court has already granted 25%. Coming to the loss of earning during the later period, court has granted 30,000. When it comes to the pain, and in all these counts, this court is of view that no enhancement is called for. Coming to the pain and suffering, considering the crush injury, this court is inclined to grant an amount, this court is granting an amount of rupees 65,000 and 10,000 legal expenses. Altogether, the claimant is entitled for an amount of rupees 3,39,000 plus another 30. 3,69,490. Yes, enhanced amount shall carry 6% interest. Any delay in this?
Yes, ma'am.
Delay.
147 days.
IA number 1 of 24 is filed to condone the delay of 147 days. Is not entitled for interest for the said period.
Please.
Yes.
7, Ravi Shankar Shastri.
For the appellant, my lord.
This
It's a case of injury. There is a dispute regarding notional income taken by the MAT, and though we have.
No, what I do is, no, the list is more, but wherever ready, that I will take up in the evening. So,
She is not ready. She is
I'm ready.
requesting this.
I'm ready, my lord. If it is okay with that, trial court record is not.
Not required.
Yeah, because.
List is matter after service of after the TCR is received. Yes, next. 8 also after TCR is received.
This is the case of death, my lord.
8.
8 and 8.
I'll hear it afternoon, after the 2:30 matters. Yes. Then 9.
Serial
A
number
week's-
9.
What about notice to R1 a week's time for taking process, for paying the process, service of notice to R1, default order?
10, Jagdish.
Pay for the appellant in this case.
10,
Kindly
what
dispensation of notice to R1, my lord, sir.
Memo is filed seeking dispensation
R3
of
is the Liberty General Insurance Company.
R1, R3 is,
Liberty General Insurance.
you appear, Pradeep?
Please, my lord, in my name, my lord, R2 is shown, my lord. Krishna Kishore has filed wakalat for R2. I will undertake to file wakalat for R3.
Mr. Pradeep is right to take notice on behalf of R3.
R3.
Number 1 of R3.
R3.
R3, that's what I said. I number 1 of 25 to condone the delay of 78 days, condone, admit, final hearing.
Please.
Yes, next 11. A week's time, default
11.
order. Default order. 12. It is submitted that the needful is done. List is matter after service of notice.
List along with MFA 951/25.
List along with so and so.
Please.
Next 13.
Delay is there.
Huh?
13 I filed memo for dispensation.
To R2. Memo is filed seeking dispensation or notice to
I'll take my lord.
R1 and R2. Mr. Jagdish, PS Jagdish is directed to take notice on behalf of the respondent insurance company. Yes, admit final hearing TCR.
Copy served.
Yes.
Only
Next.
two respondents here.
Then how are you saying that, probably, there are only 2 respondents.
1 and 2, that is.
Only one.
Only one.
Only
Yes,
one.
your lords. Only one.
Memo of dispensation to R1, R2, Mr. So and so. Admit final hearing TCR. Yes, 14. To whom?
R1.
Yes, memo is filed seeking dispensation of R1, R2 is?
Reliance.
Mr. Pradeep is directed to take notice on behalf of the respondent insurance company, admit final hearing TCR. 15.
15.
My lord, I am for the respondent number 2, my lord.
A week's time is granted for a week's time for paying the process, or else the appeal against R2. It says R2 for
My lord,
first
I am
time.
R2. I am R2. I'll file wakalat, my lord. I'll file wakalat.
Yes, the admit final hearing TCR 15.
But
Yes,
they have
sir.
not given the copy of the appeal memo, my lord.
Then list is matter for dismissal 15. No representation, list for dismissal 16.
Okay, for the appellant in this case, my lord. R2 is the Cholamandalam General Insurance Company.
Yes, Cholamandala who appears.
I will take notice.
So, Mr. So and so is directed to take notice on behalf of the respondent insurance company. Admit post of final hearing TCR 17.
17. Pradeep.
Avoid service of no, list after service of notice to R3. Yes.
Madam, 17.2, the claimant's appeal, madam. Respondent number 1, kindly notice may be dispensed with.
17.1.
Yes, madam.
Notice to
Respondent number 1, kindly
R1,
dispense with.
notice to R1 dispensed with. Pradeep is directed to take
Yes,
notice on
Liberty
behalf of
General Insurance
respondent
Company.
number 2. IA number 1 of 25 is filed to condone the delay of 240 days, condoned on condition.
327, my lord, I have filed the wakalat, my lord.
Huh?
Respond number 3276.
So then it is complete.
17.
Okay, no, so then where is wide service of notice to R3? Next in 17.
17 is shown.
No, he says he has filed from 3 to 7.
17.1.
Huh?
17.1.
That I know. In 17 is a connected appeal.
Yes, ma'am.
In 17, you have filed wakalat for 3 to 7.
Yes, my lord.
In that case, where is this avoid service of notice to R3? That's what I'm saying. It is submitted that.
My lord, respond number 326, my lord. Parents and brothers of the deceased, my lord.
If he filed wakalat, my lord, and
Yes,
repayment, what's the matter?
No, the
Will
court
undertake to
has
file
to
the wakalat,
verify.
my lord, same.
No, court has to verify who are the respondents, second or third, whether you filed or not. You have filed for R3 or not? One simple question.
No, my lord. First appeal, my lord. Insurance company appeal, my lord.
Yes.
I have filed the wakalat. Second appeal, my lord. I am appear for the parents and
In the connected matter, my lord, he is representing on behalf
Mr.
of respondent
Pradeep,
number
it's
3. He
very
wants
clear.
to.
No, it is not so complicated
My
that
lord,
I can't understand.
Please, my lord.
He said, he has filed a second appeal that I can understand.
But
In
in
the
this
first
case, he has
appeal,
not put in.
says, no, in your appeal, he says he's appearing for 3 to 7. Cause list shows that
first
3 is
appeal, madam,
awaited.
I appear for the 4 to 7, my lord.
Yes. Yes, 18.
Referring to the appellant, filing a memo of dispensation.
Yes, memo is filed seeking dispensation of notice to.
This is a connected matter. KSRTC has filed a separate appeal.
R1, 1 minute. Notice to R1 is dispensed with, list along with, give the number.
MFA is
Write on a paper and give, list along with so and so. Next 19.
I appear for the appellant in
19.
this case.
Bhargav Debut.
R2 has been served with a copy, my lord. Acknowledgement
R1,
also filed.
await service of notice on R1.
We'll await for R1.
List after service of notice to R1. 20.
20. B. Chandrasekharaya.
Yes.
Second respondent.
Appellant merit.
List after
Awaiting
service of
service
notice
and
to R1.
delay in.
That may be required.
R1, first notice has to go to R1.
Necessary, madam.
Delay has to be condoned. Yes. List after service to R1. Next 21.
21. R. Shashidhara.
I file a memo for a dispensation of service of.
Memo is filed seeking dispensation of notice to R1. R2 is already there. Next, admit force of final hearing, call for the TCR. Yes, 22.
22, my lord, awaiting TCR.
Yes, list after service of notice to R1. After service, we can condone. Notice to be served to all parties. In your case, all are served. Yes. 22.1, IA 1/25, 41 days, 47 days, condone. Next 23.
23. Pramodar.
A week's time, default order. 24.
24. R.
Memo is
Shashidhar.
filed seeking dispensation of notice to R1 and R2 dispense with, admit final hearing TCR. 25.
25.
In this
Shashidhara.
also, memo is filed seeking dispensation of notice to R1 and R2 dispense with, admit final hearing TCR. 26.
26. B. Chandrasekharaya.
Press for week time, my lord, to test it. R3 is necessary part.
Default order. Yes, next 27.
27. Muralidhara N.
For R1 and R2, Mr. Naik is appearing. For R3, I will take
Undertake
steps.
to file the wakalat.
It is submitted that Mr.
R1 to R1 to.
What is your full right?
V.S. Naik.
Naik Krishna Venkatama.
So and so,
KV
Mr.
Naik.
KV
So and
Naik.
so has instructions to file wakalat for
One and two.
R1 and 2.
I will take
Notice
steps
to
to R3.
R3.
Please.
Steps shall be taken within a week, default order. Then what about depositing of the above amount?
I have deposited, my lord.
It is submitted with the land council that the amount is deposited before the tribunal. Yes, 28.
28, I appeal for
MO is
second.
filed seeking
Today I
dispensation
have
of
received
notice
the
to
papers.
R1. IA number 1/25 to condone the delay of 6 days. Condoned on condition, admit final hearing TCR. 29.
29.
Claimants appeal, my lord.
Memo is filed dispensation of
R2,
notice to R1. IA 1/25 to condone the delay of 6 days, condone, admit final hearing TCR. Next 30, memo is filed to R1 dispensation.
Injury case.
Yes, IA number 1/25 to condone the delay of 423 days, condone, admit final hearing TCR. Next 31.
31.
2. Memo is filed seeking dispensation of notice to R1, dispensed with, admit final hearing TCR. 32. List after service of notice on R2. 33. This also list of
Madam.
service of notice on R1 and R2. 34.
KL Srinivas.
34.
New India Assurance Company, my lords, in the.
R1 is, R2 is New India
New India
Insurance
Assurance.
Company. Who appears for New India? Yes, Mr. Shankar Reddy? You don't appear. Who appears for New India?
Pushpendraya.
Huh? New India.
The Pradeep is there.
Pradeep, you appear.
Pradeep.
Pradeep is director, take notice on behalf of the insurance company. IN number 1 of 25 to condone the delay of 37 days in filing condone. Yes, next. 35.
35,
List after service of notice on R2. 36.
36. N. Uday Kumar.
IN number 1 of 25 to condone the delay of 31 days condone. Have you deposited the amount?
I have filed the extension of time, my lord, on medical ground, my lord.
Whose medical ground?
Claimant's appeal, my lord. Sorry, my lord, owner's appeal, my lord.
And then,
He is suffering.
when was the order passed?
3/9/2025, my lord.
3/9/2025 is the order.
25, 6 weeks, oh, my lord. That
Order
will,
is when? Award is when?
Award is, my lord, 18/4/2024, my lord.
So from 18/4/2024, even after 1.5 year, you have not deposited the amount. What is the extension you are seeking?
Only for 6 weeks, my lord.
First
He
of
will
all,
undertake to deposit, my
order
lord.
is 4
He is already
weeks.
filed affidavit, my lord, now.
Order is 4 weeks. And you say you want 6 weeks at, yes, this is matter with, along with the IA number 2 of 25,
3, my lord.
3 of 25. Yes, 37.
37.
My lords.
IA 1 of 25 to condone the delay of 14 days condone. 37.1.
I will take, I will.
Collected appeal.
I will file a process paid, my lord.
It is submit 37.1, Glenn Council submits that. The needful is done, list after service.
Merit.
38,
Other two matters are required to be connected.
list along with so-and-so, take that. Yes, 38.
Appear for appellant, my lord. 315 days delays may there, my lord.
Notice to the respondent. Next, 39.
I am for the claimant appeal for enhancement and notice.
Who are the respondents?
Respondent number 2 is a Royal Sundaram. First
And
respondent,
what about the notice to R1?
it may be dispensed.
Memo is filed seeking dispensation of notice to R1, dispense with Royal Sundaram, who appears? Mr. Kishore is directed to take notice on behalf of the insurance company. IA number 1 of 24 to condone the delay of 106 days, condoned on condition. Yes, 40. R. Lakshmana.
Appear for appellant, my lord. BMTC, my lord, respondent. Respondent is BMTC, my lord.
Yes, who appears for BMTC?
First, the body is there.
Mr. Dabali is directed to take notice on behalf of the insurance company. I number 1 of 24 to condone the delay of 935 days, condoned on condition. Admit fine layering TCR.
Placement.
Yes.
41.
Notice, 41 notice. Who is it? Which is insurance company? Cholamandla, who appears? You appear. Pradeep is directed to take notice on behalf of the insurance company. And what about R1?
Notice, sir. Notice is to be
Huh?
added.
Then notice to the other respondents. Yes, 42.
Appearing for the appellant, my lord.
42.
Filing this appeal
Fourth
for
evidence.
enhancement. Kindly issue notice.
No, what about the other respondents? If Tokyo is a party, other respondent is necessary. Liability is on whom?
On the insurance, my lord.
And then file a memo. How many respondents are there in this?
Only 2.
2. Then file a memo. Memo is filed seeking dispensation of notice to R1. R2 is IFCO Tokyo.
Yes.
Yes, IFCO Tokyo, who appear? Yes, BC Sivanagoda is directed to take notice on behalf of the insurance company. I number 1 of 25, 321 days, condone, admit fine layering TCR. 43.
43. Spurti Hegde.
Appearing for appellant, my lord. Again, filing this claim for enhancement and kindly issue notice.
How many respondents?
2 response. What is Reliance?
Reliance General Insurance. Mr. B. Sivanagoda is directed to take notice on behalf of the insurance company. Admit IA number 1. Memo is filed seeking dispensation.
I will do it.
Memo is filed seeking dispensation of notice to R1. IA 1 of 25, 994 days delay, condoned on condition. Yes, 44.
44. Bhagirathi.
Yes, IA number 1 of 25 to condone the delay of 213 days, condoned on condition, admit fine layering this year. This also 211 days, 45, condoned on condition.
It can be referred to other minutes, 45 minutes.
Condoned. Let's refer the request of the parties. Place this matter before the Lok Adalat.
Please.
Next 46. 46 days. Manager, New India Assurance Company. Who appears?
Krishna Kishore.
Krishna Kishore. Yes, Mr. Krishna Kishore is directed to take notice on behalf of the insurance company, admit the delay of 46 days condoned, admit final hearing TCR. 47, IA number 1025 to condone the delay of 316 days condoned on condition, admit final hearing TCR. 48,
48, Jagdish.
1 of 25,
Kindly
258
refer to
days
local.
condoned.
Refer to local Adalat.
IA 1 of 25 to condone the delay of 258 days condoned, at request refer to the local Adalat. 49,
49, Vasant Kumar.
1 of 25 to condone the delay of 104 days condoned on condition. Next 50.
50,
Yes, Shivana, you want to file objections or can I condone on condition? IA number 1 of 25 to condone the delay of 1006 days for the reasons stated, condone. Condone on condition. Next 51.
51, Kailash
Condone
Shankar.
on condition, admit final hearing TCR. 51.
51, Kailash Shankar.
1 of 25 to condone the delay of 78 days condone, admit final hearing TCR. 52. This
52,
also
my lord,
69 days
69 days.
condone.
I'm for the respondent.
69 days condoned, admit final hearing TCR.
53.
I'm filing a
Uh.
request for R1 investment.
Memo is filed seeking dispensation of notice to R1, dispensed with. Who is R2?
R2 is the.
R2, Mr.
case
Jabari is
certification.
directed to take notice on behalf of R2. Delay of, in 53, delay of 268 days, condoned on condition. Then in 2 and 53.1, 16 days condoned. Yes, 54,
Without interest.
admit final hearing TCR.
Without interest.
That is without interest, 268. Yours also? Yes, 54.
272 days. Nandini.
272 days condoned on condition, admit final hearing TCR. 55,
Appellant, my lord.
Shekhar.
448 days condoned condition. 56,
Call for record, my lord.
admit in all this,
Oh, please,
don't
please,
worry.
Please,
56,
My lord, already served the appeal memo, my lord.
IA number 1 of 25 to condone the delay of 154 days, condoned, admit final hearing TCR. 57, 103
lord.
days condoned on condition, admit final
Case
hearing.
of death, my lord.
Then what you do is this 57 and 57.1 list on 12th of November.
Records maybe less.
Huh?
Records TCR.
We are on what ground?
Negligence as well as the quantum mode.
Then list this matter, the admit final hearing, call for the TCR, list it on 27th of November. Yes, 58?
58, my
Preparing
lord.
for respond number, please.
Yes.
IA kindly.
My lord, only with regard to the income.
IA number 1 of 25 to condone the delay of 339 days, condone. Can we
Subject
take
to-
it up on condition?
Yes.
So we will take it up on 12th.
Next week, yes. Yes, sir.
List this matter on 12th. Then 559, admit final hearing, 60, all these matters, admission matters. If it is any of the matters or a case of death, we will take it up.
In this case,
Only remand.
the claim petition has been dismissed. by
Which
the lower
ways?
court. 60 number,
60
number 60 Mela.
Yes,
Remand to the tribunal.
it has to be remanded.
There has to be
So
remanded.
60 pass over, 60.61 pass over, no,
61.
60.1, my.
60.1.
61.
61 admit,
61, my lord, other connected matters.
61 post along with so and so, admit final hearing. 62,
I am for the appellant, my lord. I want to
Appeals
serve
have
the-
not been served.
I will serve.
is 62 admit final hearing, call for the TCR. 63,
Yes, my lord. TCR is necessary in this.
admit final hearing TCR. 64,
64,
I will serve the copy to.
admit final hearing TCR. 65,
65,
the manager Cholamandla, who appears for Cholamandla.
I will take notice, my lord.
Mr. Vijay Kumar is directed to take notice on behalf of the respondent insurance company. Admit final hearing TCR. Yes. MFAs are done for today.
My lord, serial number 2. List number 2, serial number 23, my lord. Kindly notice may be order, my lord.
20.
23.
What were you doing when the list is
Sorry, my
called?
lord. Sorry, my lord. I appear for appellant counsel, my lord. This
In
one
which
number-
case?
List number 2, serial number 23, my lord.
Serial number 23. What happened? Oh, 23.
Please.
Pramodar.
Pramodar, my lord.
You are seeking dispensation to?
Yes, my lord, respond number 1, my lord.
Memo is filed seeking dispensation
Respond
of
number
notice
two,
to
my lord, United
respondent
India
number
Insurance.
1. 2 is?
United India Insurance Company, my lord.
Who appears? Mr. Shankareddy is directed to take note. Your,
Vrishabhendraya.
Vrishabhendraya is directed to take notice on behalf of the insurance company.
My lord, serial number 8, my lord. I have to file wakalat in the connected matter.
Please don't tell all that, Mr. Vijay Kumar, after the list
Kindly-
is over.
next week.
Anything for signature? Yes.
My lord, serial number 60, my lord.
In which matter? Tell to the court office.
My lord, serial number 60, my lord, pass over it, my lord. Kindly have take one. Date, my lord, is afternoon. 16 second.
Whatever he wants.
My lord, it's a passover matter, my lord, serial number 8. Kindly call next week. I'll file wakalat.
On date. Sir. Madam, ಅದೊಂದು date
After service.
ಡೇಟ್ ಯಾವ್ದು?
Just after service.
ಸೀರಿಯಲ್ ನಂಬರ್ 60 ಇದೆ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಯಾವ್ದಾದ್ರು ತಗೊಳ್ಳಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ದಾಗ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ದಾಗ ಒಂದು ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ.
ಸರ್
12-13 ಯಾವ್ದಾದ್ರು ಹಾಕಿ.
245
ಏನು?
ಮಧ್ಯಾಹ್ನ
15 ಬೇಡ, 15 ವರ್ಕಿಂಗ್ ಡೇನಾ? ಸಾಟರ್ಡೆ.
ಅದು ಎಷ್ಟೊತ್ತಿಗೆ ಬರ್ತಾರೆ ಅಂತ ಹೇಳಕ್ಕಲ್ಲ ನೋಡಿ, ಇವಾಗ ಲೇಟ್ ಆಗಿ ಕೂತಿದ್ದಾರೆ, ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿ ಬರ್ಬೋದು, ಗೊತ್ತಿಲ್ಲ.
12-11 ಹಾಕಿ. 13 12 ಹಾಕಿ ಮೇಡಮ್.
230 ಇದೆಯಲ್ಲ ಫಿಫ್ತ್ ಲಿಸ್ಟ್.
19 ಸರಿ.
ಲಿಸ್ಟ್ ಯಾವ ತಗೊಂತಾರೆ ಮೇಡಮ್ ಕೇಳೋಣ.
60.1
ಮುಗಿತದ ಬನ್ನಿ, ಕಡಿಮೆನೇ ಇದೆ ಇವತ್ತು ಮ್ಯಾಟರ್.
60.1 19.
Serial number 60.
Bill number 36 in list number 1, my lord. Next Wednesday. Next Wednesday.
Is passed over. Yes.
My lord, submission. Earlier, serial number 43 and this too, I wrongly submitted that the insurance company is liable. Actually, the respondent one is liable. So kindly issue notice.
Why did you say so?
Sorry, my lord.
Yes. Take the. In that
There are small
matter,
submission, my lord.
notice to the so and so is necessary. Tell them.
My lord, earlier on 27/10 in MFA matter 5660 of 25 and withdrawal application was filed because in trial court the case was settled. Order is already given, my lord. Kindly.
Why when I specifically say no mentionings, why everybody is coming and mentioning at this hour? Yes, call the list.
No, my lord, not today's case, my lord.
Whenever it is. No, I will not, I'll not hear. Yes, 230. Just call the 230 list.
Appearing for petitioner, your lordship.
And for the respondent bank, I'm filing a memo reporting the sale of the secured asset in the one of the mortgage property.
Your lordship.
Interim order as paid for till the next date of hearing, subject to petitioners depositing with the respondent bank 30% of the amount. Failing which not only the interim order stands decided on its own, but the petition runs the risk of being rejected per se. What happened?
Your lordship, the other connected matter has become infructuous, your lordship. However, there are two submissions, your lordship. They have filed one impleading application IA number 1 of 2025 and the memo that they are placing on record. We have not been served the copy and senior is not available. If it may be taken up after some time, your lordship. Next week, your lordship.
Have one submission.
I will allow the implead petition. Your objections are not at all required. He's an auction purchaser. Well, what could be your objection for that? He will give you a copy. I will allow it.
We want to file objections to the.
My objection.
You can't have any objection for that. If he's an auction purchaser, he has to be heard.
Please, your
It is an admitted fact.
Please.
Yes.
The writ petition, the present writ petition is challenged the possession notice.
The possession for, yes.
Possession notice. I have taken physical possession. I sold that particular property, one of the property, and the petitioner has got the remedy before the DRT, not before this honorable court. From the
What
date
are you doing from 26/2023? Interim order in 2023. When did you file the vacate petition?
In fact, I appeared this matter by taking NOC, my lord. My predecessor, my letter. I need to check.
That's what the bank is happily keeping quiet from 26/2023 with an interim order. Then what the court should understand with this?
Your lordship, in the interim, they have gone ahead and sold my assets and property, your lordship.
Have you paid this amount of as per the order of the court?
They have already recovered the amount by selling my assets, your lordship.
I said, have you complied with the interim order dated?
I will take the calculation, your lordship.
Kindly pass out the matter. I will.
No, not calculation. I'll take up this matter. Today is third. We will have this matter on 10th. I'll list this matter on 10th.
Your lordship,
Sorry, my lord.
10th senior is not there any day after 10th, your lordship.
7th.
Please.
This is matter on 11th.
Lords.
No further issue.
Sorry, for the bank, my lords. First matter, my lords, order is Delhi court's order. ACMM Delhi court under 14. That is challenged here in respect of a property.
Which is in Delhi.
Delhi, property is sold. Your lordships, my lords, can't interfere. The magistrate's order.
No, that's what I was telling him. Order is passed 2023 interim order. Bank is comfortable, happy with
In
the
fact,
order.
my lord, what was happening was it was not getting listed or listed and not reaching. That's the problem.
So anyway, we will also accommodate them 10th.
11th.
No, it is submitted by the senior counsel appearing to the respondent that the section 14 notice, the order that is passed is by the courts at Delhi. And the
First
property,
one matter.
property,
In the first matter.
I'm referring to first only.
Yes,
In
ma'am.
1069 and the property is in Delhi. It is submitted that the bank has put the property to auction.
And sold.
I am the auction purchaser
who is
dwelling in the property right now.
Auction purchaser is in possession.
From 14 June 2024, I'm dwelling in that house, my lord.
2024, he has been in possession of the property. Land counsel appearing for the petitioner submits that there is inconvenience to the arguing counsel or senior counsel.
Arguing counsel, Your Lordship.
Difficulty to the senior counsel. Hence, as a last opportunity, list this matter on 10th. No further
11th, Your Lordship.
11th, no further adjournments will be granted. The cause list should also reflect that.
My intervening application can be formally allowed
That day I
as
can do,
respondent.
that day we can do both. Serve them a copy now.
I've already served it, my lord. I've served my sister the next day.
Serve it now.
I've served it. I'll serve it again.
Yes, yes.
Anyway, they are aware of it also.
Lord, sir, my instructions are that parties are exploring settlement. We have submitted an OTS offer which is under consideration. Only 10 days time I'm seeking. It may
Lords,
list after 10 days. If there's no, I'll
I'd like to
argue on
appear
merits.
for respondent number 2, my lords. In fact, the petitioner
for the
has
respondent number 1.
executed deed of confirmation, my lord.
1 minute. The respondent bank shall place on record so and so. 3/6/2025 status quo qua the property as obtained today be maintained by the parties on 29/4/2025. 3/6 interim order is extended.
After that matter did not reach many times, it was
1
listed.
minute. The interim order is granted till the next date of hearing. Interim order is extended. Interim order is extended. So, when was this auction?
Auction held on 28/2.
No, 28/2 is a sales
A sale
certificate.
certificate issued. Auction was on 14/2/2025.
14 to?
2025.
This order is on
Sale certificate was,
29/4.
yes, ma'am. All auction sale certificate.
What is question in this writ petition?
The sales certificate itself, my lords.
On what ground?
The ground that the sale notice was not issued to us, that was our principal contention along with other things. But the situation now is that I'm told that bank is also considering the OTS settlement
How
offer.
can it be already
Yes,
or the sale certificate is
All that I
issued?
request is for, my instructions are only to take adjournment for 10 days. It may be, date may be given. I'll argue on merits and your honors may pass any orders. I'll not insist more than that, my lords. I mean, this is my situation, unfortunately. I'll not.
Unfortunately, in a
I
matter
understand.
of this nature.
I understand.
You will not get, even after 10 days
I
also,
understand.
you will not get any relief from
I
the
myself
court.
have argued on the others, so I will not insist.
My lord, OTS is for additional,
get it.
whatever the additional amount payment.
All that
For
I'm seeking
purpose.
for is
It's
10 days,
already
nothing more.
Sale certificate is registered in the sub-registrar office also. And possession also delivered to the.
My lords, I have one
I'll
submission.
not
my lords.
dispute
I
any
have-
of those. Only 10 days I'm seeking. After
My
that, it
lords.
may be listed.
I'm for the auction purchaser, my lords, respondent number 2. My lords, I'm just passing on a deed of confirmation that is executed by the petitioner in favor of the auction purchaser, my lords.
Do that. When was this?
26 September 2025, my lords.
Then what remains, Mr. Counsel?
This is,
I'll take instructions, my lords. Only.
Here, what instructions you will
It may
take?
pass over.
Yes.
May pass. I'll
Pass
take
over.
instructions.
Because
immediately.
having executed a confirmation.
understand.
It's-
I understand.
Yes, pass over.
Please.
Next matter.
Can it be taken it in the next week, my lords? Senior
Paper
is out
served?
of station.
Sir, they have served.
Yes, let's see. I think there is no interim order.
No minutes.
Yes, at the request of learned counsel, the petitioner, list this matter on 11th of November. No further adjournments will be granted.
For respondent bank.
Where is the petitioner?
The last date, my call
Yes.
was
There
directed
is,
to.
1 minute, 1 minute. On 30/10/2025, this court has directed the petitioner to file an affidavit as he is ready to pay the outstanding amount. Accordingly, for filing the affidavit, the matter is listed today. And also, there is a specific direction that by 3/11/2025, the affidavit shall be served on the respondent.
And not.
Then counsel for the respondent submits that. So far, the affidavit is not served. This is matter for dismissal tomorrow. Yes.
Not appearing for the
I
respondent,
appear
my
for
lord, this
petitioner
possession
in this
notice
case,
is
my
being
lords,
served.
1 second.
Let's,
Let's,
I filed an
we have
IE as
filed
well.
application, my lord, seeking for withdrawal of, my lords, the amount deposited by us pursuant to the interim order passed by this honorable court. So I'd like to file objections to that effect, my lords, to that application. The reason being this, my lords, the initial understanding was for, my lords, 140 installments. We have, my lords, paid the entire 140 installments.
Come to the, what is that order? What is?
Order is under,
Interim order based on which the stay was granted, they
Lords,
instead
Annexure
deposited in
A,
bank,
page-
they've deposited in court.
1 minute, 1 minute.
Annexure A, page 16, possession notice is under
The
charge.
petitioner shall deposit 3,50,000 within 3 weeks from today.
Then again,
And the
3
sum
lakh.
of 3,50,000 shall be deposited within
Yes.
another 3 weeks thereafter.
He is not deposited in.
Any deviation in paying the aforesaid amount within the timeline as stipulated would entail vacation of the interim order and would also run the risk of dismissal of the petition itself. And
We have complied with.
1 minute, agent to be called in the week commencing from so and so. So when did you pay the
My
amount?
lords, one is on 23, 120.
Huh? Please give the dates.
Lords, on 14, 23, 1, 2024. my lords.
23,
1, 2024.
how much you paid?
3.5 lakh rupees.
The date of order is 14/12.
Another,
Date of order is 14/12. You paid on 23/1.
Yes.
Where the 3 weeks is already over by the time.
another payment is also made on the same day, 23, 1. Second compliance. 3.5, 3.5. Both are compliant on the same day.
Paid 7 lakhs.
My lord, they have not paid to the bank. They've deposited in court. That's why I filed an application. Now having, my lord, they have made payment, but it has to come to the loan account. That is why they've enjoyed the stay. It's not come to the loan account. They want to file objections to that. My lord, the whole petition itself is to be dismissed on account of
We will
alternate
decide
remedy.
the main application itself. Please argue.
Please.
My lord, I may be permitted to withdraw the amount, my lord, because he's.
I'm disposing of the
Yes,
matter.
yes, my lord, yes.
My lords, possession notice at annexure A, page 16 is under challenge. Lords, petitioner availed loan, my lords, no doubt about it, my lords. 41 lakh rupees loan was availed.
Yes.
41 lakh rupees loan was availed.
Hmm.
But so the understanding was to pay the same in 140 installments. But so as could be seen from my lords annexure B, the statement of account, 140 installments are my lords paid. There is no dispute regarding that. But so in spite of repayment, my lords, the respondent bank proceeded to issue the notice, lords, which your lordship will get at annexure C, page 35, demand notice. Lords. We have submitted a reply, my lords, saying we are not liable to pay any amount and the entire outstanding amount is paid. Lords, which is available at annexure D, my lords, page 38. There, my lords, we have furnished the details of the payments made by us, which your lordship will get at page 39.
What is the response to this?
My lords, they have come up with another reply, my lords, which your lordship will get at, my lords, page 55, page 52, annexure E. They say, my lords, we are liable to pay, my lords, additional amount, and you have not cleared the entire loan amount. Then, my lords, one more notice, demand notice, my lords, they have issued. Then, my lords, I have filed a consumer complaint, my lords, pointing out the irregularities committed by them. And that complaint came to be dismissed and appeal is filed, appeal is pending for adjudication. In the meantime, my lords, they have come up with the present possession notice.
They've issued a 13-2 notice.
Yes, my lords.
You submitted your
Objections.
objection. They have issued their response to that.
Yes.
Where have they considered your response or not?
No, my lords. They
What is your?
kindly see, my lords, my reply is at annexure D, page 38.
Yes.
Kindly see, my lords, para 3, which is available at page 39. I have pointed out 140 installments, how I have paid.
Now, please come to their response.
Response is at my lords annexure E, page 52.
Come to paragraph number
Yes.
6.
Regarding para 3. Governments made in para 3 of your notice that your client and co-applicants have repaid the credit facility to the bank are false, untenable and baseless. Please note that your client had not repaid the amounts as stated in your notice by serial number so and so, which are unrealized interest amount. The interest amount charged to the loan account during the period which was again bank reversed to the loan account due to account became NPA. Please note that your client had not paid the amount claimed in para 3, that is so and so. Regarding para 6, this is what they say, my lords. So since they have treated this particular account as NPA, they have not realized this particular amount. Now, my lords, subsequently, my lords, in the month of
As far as complaints of Rule 13(3)(a) is concerned, there is no difficulty. They have answered.
they have replied. Then now
And they have considered whatever is your, whatever is
my
your objection.
contentions.
that is, They said, because of this, the outstanding is so and so.
Yes. Now, my
Then
lords,
they have issued the notice under section 13(4).
13.4. Now, my lords,
Wrong with that.
now, my lords, my respectful submission is, my lords, when we have taken up a specific plea that, my lords, pursuant to their demand, my lords, we have paid 31 lakh rupees so as to, my lords.
What is your answer to this? The interest amount at paragraph number 6
Yes, my lords.
till end, they have given an answer to that.
We have, my lords, their contention is that is unrealized interest amount. And since they have not realized that amount, since, my lords, the account is NPA. But, my lords, my instructions are, my lords, this amount is, my lords, with them only. They have not reversed it to us. It is not their case, my lords. They have reversed it to the petitioner. It is still lying with them only.
So what is outstanding?
My lord, outstanding now is 36 lakhs, my lord.
As on the
36
date of issuance of notice, it was 26 lakhs.
Yes, now.
No, it has become
They have
36
not.
lakhs.
Yes, 30, it's become
Only
36
Either
lakhs.
the option is, no, you have to pay this amount or you have to go before the DRT.
So with that observation, DRT, my lords, this can be disposed.
Yes. And the amount, or whatever is the amount that is lying before this, they will withdraw the amount because you have enjoyed the stay.
But ultimately, my lords, they have realized the 41 lakh rupees
No,
was
but
the loan amount, and
Over we say that deposit before the court. What is the
Yes.
purpose of depositing?
no, that is the order. My lords.
No, my lord.
That's what I'm saying. Maybe that is mentioned. The purpose of depositing before the court is neither here nor there. Please come.
In fact, it is not mentioned that it's court, my lord. It was deposit. And my lord, all the time it is deposit before the bank. It is never before the court. It is essentially
But,
spiteful on the fact that they deposit and they don't
It is
want to.
easy to say, my lords, it is always with the bank, my lords, when the
No, no.
order does not say so, my lords, they cannot contend that it
It's
is
understood, my lord.
with the
It is
bank.
understood.
The
All
present
surfacey matters, they come
petition
and
is filed.
deposit in bank.
Seeking the following clear. The facts of the case are the petitioner and one
May
Syed Hussain.
interfere. Parties to hesitate their rights before, my lords, DRT.
The petitioner and one Syed Hussain are the absolute owners of the property. That is residential site number 5, PID number 2-245-5, with assessment number 296 in number 38, Purnapura Village, Bangalore, North Taluk.
Make one more request, please. Next matter is, next court, my lords, my matter.
This is now
Grateful,
called
my colleague.
First Cross Pipeline Road, MES Road, Bangalore. Ward number 2, Yeshwantpura, Bangalore, with building thereon, standing in the building thereon. They've obtained the loan from the respondent bank of an amount of rupees 41 lakhs on 17/11/2007. The petitioner and the co-applicant had repaid the credit to the bank in a total sum of 86 lakhs 32,903 through 140 installments on various dates. The first installment of rupees 29 lakh 442 was paid on 8/3/2008, and the last installment of a sum of rupees 7,500 was paid on 12/8/2021. It is the case that in spite of paying the entire amount, the bank has initiated the proceedings under section 13(2) of the Surface Act. And the notice was issued on 11/10/2021. Upon receipt of the demand notice, the petitioner had sent reply on 25/10/2021. It is a case of the petitioner that when he has given a reply to the 13-2 notice, the respondents have not replied to the same, to the grounds that are raised in the said reply. And in a mechanical manner, now a notice under section 13(4) of the Act is issued by the respondent, which is in challenge before this court. When this matter came up for admission before a coordinate bench of this court on 14/12 for a preliminary hearing on 14/12/2023, an interim order was passed directing the petitioner to deposit 3,50,000 within 3 weeks from today, from the date of order, and another sum of rupees 3,50,000 within another 3 weeks. And any deviation in paying the amount within the timeline as stipulated, even of the first instance, would entail vacation of the interim order and would also run the risk of dismissal of the petition itself. Next paragraph. Land counsel appearing for the petitioner submits that as per the order, they have deposited the amount on 23/1/2024. It is a contention of the land counsel appearing for the respondent that the amount is deposited before this bank. Hence, they have come up with this application seeking permission by the bank seeking permission to withdraw the amount. It is submitted that the bank ought to have, the borrower, the petitioner ought to have deposited the amount with the bank, and it cannot be deposited before this bank because this court. It is submitted that in the reply that is given by them, they have categorically mentioned how the amount is outstanding and how the NPA is, how it is declared as a NPA. It is submitted that, and when a notice under section 13(4) is issued, the petitioner have an effective remedy of approaching the debt recovery tribunal under section 17 of the Surface Act. It is submitted that that there are no grounds to interfere with the possession notice which is impugned before this court. In response to that, land counsel appearing for the petitioner submits that as far as an application, the IA that is filed to seeking permission to withdraw the amount, it is submitted that he wants to file his objections. It is further submitted that the declaring their account as NPA itself is illegal, as I have already paid the amounts. Next part, having heard the counsels on either side, there is some material on record. When a 13(1) notice is issued under section 13(2) of the Surface Act, the petitioner has given his reply. In the reply, he has stated that he has been continuously paying, there is no default on his part. To that, the bank has given a reply, clearly stating that the manner in which the account is declared as NPA and what is the outstanding amount. What is the outstanding amount? It is now the petitioner submits that he is disputing the same. All these disputed questions of fact cannot be decided by this court and 226 of the Constitution of India. When as per the Act, when a provision under section 17, when he has a right of when the borrower can approach a DRT, this court cannot entertain the writ petition under these in these disputed questions of fact. In that view of the matter, this court is passing the following order. The writ petition is dismissed, giving liberty to the petitioner to avail the appropriate remedy in accordance with the law. Number 2, the amount that is in deposit before this court, the bank is at liberty to withdraw.
No, the petitioner may be directed to revalidate the DD if required, my lord.
If the,
That is already realized by the bank. They have to take application and they have to withdraw that amount by the court. May I make one more request, my lords? Since my lords have complied with the interim order, my lords, now when I approach the DRT, my lords, they'll ask me to deposit, my lords, additional amount, my lords. This amount may be considered, my lords, because
Just for DRT to consider, my lord.
unnecessarily I'll be burdened, my lords, when I'm disputing the liability itself, my lords.
In fact, that has not reached the bank, my lord.
No,
It is.
see, I'm not on
it is a
that, my lords,
question of-
whether it reached the bank or not.
They are being.
No.
They are-
once the amount is realized by the bank, the amount that is spent, the deposited and that is withdrawn by the bank. And while the DRT, while considering the appeal, if any amount has to be deposited by the petitioner, the amount that is already is with the bank and by way of the interim order, which is deposited in the light of the interim order passed by this court, shall be considered by the DRT.
Grateful, grateful.
Yes, next.
Swaroop, yes.
For the petitioner, my lords.
Yes.
Page number 17 is a demand notice. 13-2 notice of challenge, my lords. Page number 17. Annexure A.
What about your response?
My lords.
Your response to 713-2.
13-2, I've also issued reply, my lords, at page 21. The dispute is very simple, my lords. I'll just explain. As per the demand notice, the due according to them is about 8.86 crores. While there are 7 properties which are secured for the said loan. As per the due, as on 29/7/2025 is about 8.86 crores. As of 2022, bank itself has taken valuation of all these properties, only the 6 properties, which is about 34 crore rupees, which is about 550 times the demand amount what is there as of 2025 also. But as of 2022 itself, the property value was about 35 crores. The 7th property is 2 plots. Even excluding that plot, the valuation was about 35 crores. All that I'm seeking is, I've requested them to release those 2 plots from the security because it doesn't affect their loan in any way. I'll liquidate that, pay the entire dues to the, I'll undertake, we'll put an escrow account, I'll pay the entire dues to the bank, regularize my account. That's all my request
When
is.
you've taken 8.86 crores, why did you mortgage the properties worth more than 35 lakh crores?
My lords, this is a resort. So these are all, I'm running a resort in Kurk. So these are all properties which are attached together. They said that I have to mortgage. I had loan requirements, so I mortgaged the entire properties. All that I'm requesting is these 2 plots will fetch the amount which will regularize the account. Immediately, entire sale consideration, whatever comes, I'll deposit in favor of the bank to my loan account. It's a very fair request, my lords.
My lord, my instructions, my lord, in fact, my lord, they given a reply to my lord, my 13-2, which may also, my lord, kindly come to my lord, page number 130.
Is it correct that the property is valued at 35
Lord,
crores?
as per the valuation at the time of taking the, my lord, property, it is a fact, my lord, valuation report before this honorable court. That I cannot dispute in this junction. Now, recently, we are not able to conduct a valuation because my instructions, my lord, the petition is not, my lord, permitting us to visit the property, and my lord, we are not able to take the, my lord.
I will facilitate whenever
But
they say
however,
we'll facilitate.
valuation before this honorable court, at the time of sanctioning, my lord, that is a value which we pay.
No. If you have no difficulty in sending your valuer and valuing the property, and they're also coming forward, do it. You want to secure your amount. And first of all, why did you insist for this mortgage of 35 crores worth of property?
In a open eyes, my lord, there, my lord, created a mortgage in my favor. That is, my lord, now, my lord, they can't.
Anyhow, we'll not go into that. Please, let's send your valuer to value the property.
Right. Any day, my lords.
And
Any day.
when your amount is secured, you don't want their property just like that.
We don't want to default. We'll pay the entire amount, whatever comes. Even if it's excess of this amount, we'll deposit in favor of the bank.
My lord, in
They can
respect
take the
of
entire
release of property, my lord, I need some time. My lord, in respect of release of, my lord, 2 security which they're seeking before this honorable court, I'll secure instruction, I'll make a submissions. My lord, let him, my lord, undertake before this honorable court. He will, my lord, I'll arrange the, my lord, valuer within this week. And my lord, let him, my lord, my lord.
So whatever you filed an IA in that regard, or you're submitting orally?
I'll file a memo.
So you file an affidavit, whatever that you're submitting before the court, and serve on him.
Certain.
And then they will, then you can send your valuer.
That is one aspect, my lord, that definitely, my lord, will consider. In respect of, my lord, a due, my lord, 2022, my lord, account become NPA. Thereafter, my lord, my instructions, my lord, he's not made any attempt to, my lord, Some money also, my lord, some bona fide, my lord.
My lords, I'll deposit the entire consideration to
Oh.
them.
See that, like, he has taken the loan, and also an admitted fact that for a loan of 8 crores, he has mortgaged property of 35 crores in the year 2021.
Hold on, my lord.
So that's why where it is required, you can ask for that, not in a case of this nature.
Please, my lord, then.
The learned counsel for the appellant, the petitioner submits that in the year 20.
My lords, 22 is the valuation report.
In the year 2022, he has borrowed an amount of rupees 8.86 crores. And as per the valuation certificate as on that day, the property is worth rupees 35 crores. It is submitted that the present outstanding is
9 crore, my lord, 5,60,736 as on
9 crores
30th.
5,60,000.
736 as on 30th 9.
76,000. It is submitted that in that property number 7.
Property numbers.
Number 7 is number 7 consists of two plots,
industrial plots.
Industrial plots, and already as the remaining property, the bank's amounts are secured as it is as on today it will fetch more than 30 crores. If the property is if they value the property. And if that property number 7 is released, he will sell the property, and whatever is outstanding amount, he will pay the dues to the bank. Then counsel appearing for the respondent submits that for the first time he is submitting before this court orally, and he need to get instructions in this regard. Then the petitioner shall file an affidavit with whatever he wants to, how he wants to proceed, and give a copy of it to the respondent, and the respondent shall send the valuer for valuing the properties that are mortgaged, and what is the feasibility of releasing.
My
And
lord,
also
my submission is the primary security which, my lord, I have to do inspection and I have to conduct a valuation. The petitioner is, my lord, not supporting
that's
that.
what now he is saying that he would. Now he is saying he would file an affidavit. And what is the feasibility? The respondent shall file a memo before this court with regard to the feasibility of releasing the said property. This is matter. When can you file an affidavit?
My lords, within a week's time, I'll file it.
This is matter on 11th of November.
11th. Lord, maybe.
In the meanwhile, my lords, the demand notice may be stayed, my lords. In the meanwhile.
I have one submission. It's not that, my lord, I don't have any instructions. My instructions are this. He is not supporting to take the valuation.
Now, please understand, what he is saying is, now, in the form of an affidavit, he will say that I have no objection for the bank to come and, value the property. That's what he is saying.
It may be taken on record, my lord. My lord, which I made.
Then counsel for the respondent submits that whenever the bank authorities are approaching for valuing the property, the petitioner is objecting. Then counsel for the respondent submits that they have no such objection, and they'll ensure that the valuer values the property. Yes.
He will cooperate and he'll
Cooperate with the valuer and cooperate with the valuer.
Any short.
This is matter on 10th.
11th.
11th. This is matter on 11th. You have to serve him that affidavit
in advance.
In advance by 10th.
Certainly.
The counsel for the petition shall serve the copy of the affidavit to the counsel for the respondent by 10th. And you have to get instructions, whatever you want to file by 11th.
And I'll file my objection.
Yes. Next.
In the meanwhile, demand notice may be.
Till the next date of hearing. No further, the respondent shall not take up any, shall not proceed with, shall not take up any coercive steps.
Great. Great.
Yes.
Number 7, Kumar.
Yes.
Petitioner has taken the property on lease, my lord, from respondent 2 to 4. The petitioner has taken the property on.
Coming up for the first time.
Yes, ma'am.
23 matter. What remains in this petition? A writ petition of 23 coming up for hearing without notice to the respondent for the first time.
It came up before, my lord, but it
never notice ordered.
Did not reach.
Office objections were complied on 10/3/2025 and a writ petition of 2023. What is that is questioned? I think nothing to be adjudicated in this writ petition. And when
My lord,
nothing is happening from 23. What is the relief? Please come to the
Please,
prayer.
my lord,
To issue a writ direction quashing the possession notice dated issued by respondent number 1. What has happened from there on? No interim order.
no interim order, bank has not taken any action. My
Who
lord,
appears for the respondent, which is the
it's,
take out notice on all the respondents. The petitioner shall take out notice to the respondents. In addition, petitioner shall take out hand summons on all the respondents and file a memo. Once the memo is filed or the notice is served, this is matter. Yes, 9.
Number 8. Shetty
Eight.
Vignesh.
Yes.
In fact, my lord, last time matter came up on board, the respondent sought time to file his objections. My lord, I am not sought any stay of my sale notice. My lord, here the case, my lord, the violation of my lord Article 21. My photo has been published in the my lord sale notice, which is not permissible under law. This honorable court and various high courts, my lord, which I produce the compilation of judgment.
Yes, Mr. Lokesh.
Lord, the main prayer was to quash the sale notice dated 11/1/2025, where thereafter, after filing this writ petition, he filed
Where
appeal
is the
before
sale
DRT
notice? Show the sale notice.
11/1/2025.
My lord, page number, my lord,
43.
43. My photo.
What is this 43 notice?
43 the sale notice, my lords.
Oh, it is
This
necessary
sale
that
notice
you
was
print the
Lords,
photographs.
Lords, photographs can be published. There are various case laws supported with the High Court, various High Courts supporting the publication of sale notice for defaulting defaulters. May I just a minute, my lords, only one before going to this, my lords, the sale notice kindly come to prayer. Lordship may kindly come to prayer. To quash the sale notice, come tender notice dated 11/1/2025. Thereafter, filing this writ petition, he filed a appeal before DRT. DRT has upheld the sale and dismissed his case 4 days back in SA 72 of 2025. With respect to second prayer is concerned, my lords, there is no cause of action for him to directly file the writ.
Stay on the sale notice because it's recovery of money, which I am, my lord, that is the reason I gone before the DRT. Here, my lord, I am on limited prayer. Right? My lord, it is Article 21, my lord, kindly, my lord, there are various judgment passed by this honorable court. My lord, kindly come to my lord, the compilation of judgment.
So now what are you expecting the court to do?
My lord, either, my lord, they have to ask some apology from this. That's what happened in the earlier cases which passed by this honorable court pass in order. My lord, they can't publish it. My lord, there
No. Let's see your grounds.
prayer. My lord, prayer 1.
No. When was this part? When was this filed, this writ petition?
This petition filed on 31/1/2025, my lord.
31/1/2025.
2025.
When is the order passed? When did you approach the DRT?
DRT, my lord, subsequent to this.
When? When did he approach the DRT?
Lords, very after 1 week after this, approximately maybe in the first week of February.
When is the order passed?
4 days, 31st October 2025. In fact, he had made same pleadings before DRT, which
It's not
Let's
correct,
see the prayer.
First prayer, my lord, cautious sale come tender notice dated so and so. The prayer B, to direct the respondent bank to tender an apology to the petitioner for an act of publishing their photographs with the sale come tender notice dated 11/1/2025 in Prajavani and Deccan Herald newspaper of the Karnataka region, annexure B.
What are the judgments you are relying
Please,
on?
my lord. My lord, compilation judgment, I filed it on 7/2/2025, my lord. The first
copy is
judgment.
not served on, judgment's copy is not served on me. Let him serve
I
a copy
served.
on set of copy.
I served, my lord, across the park. My lord, my friend took a time to, my lord, file his objection. It is recorded.
No,
Mr.
case
Lokesh,
law,
can't you appear?
case law
Can't you
copy is not
appear?
served.
No, regularly your matters are coming. Can't you appear in person in the
Lord,
court?
case law compilation judgment is not served. Petition is copy is served.
It is not correct.
I'm sorry, Lord, for some personal inconvenience. I could not appear.
My lord, the first judgment which I relying, my lord, Venu PR versus Assistant General Manager, State Bank of India and High Court of Kerala, page number 2, my lord. The judgment, my lord.
It's not here. Court officers. It's there in the file.
Any of files?
3.
She is not there.
Am I permitted to file?
Yes. Yes.
paragraph number, my lord, 3 and 8. In the first judgment, my lord, page number 2. No doubt, the bank is entitled to file a suit or initiate proceedings under the Securitization Act for the relation of its dues. The bank can also resort proceedings under the Kerala Revenue Recovery Act 1968 for relation of its dues. In respect of certain categories of loan advance, the decree obtained from the civil court can be put to the execution of the security interest enforced under the Surface Act. Revenue recovery steps initiated against the defaulter, but there is no provision in any of the enactments enabling the bank to threaten the loanees about its intention to publish their photographs on leading newspaper on failure to repay the debt within a specified date. My lord, I'll skip the remaining. My lord, I'll come to my lord, paragraph number 8. There is nothing immoral in being unable to repay the loans availed of owing to the flundering of business or due to some other unavoidable reason which can enable the bank to infringe the right of privacy of loanees. There is no compelling public interest warranting the publishing the photographs of the loanees in newspapers, in which case only the right to privacy has perhaps to give away. Some of the loanees may even be driven to commit suicide to fear the ignominy of publishing their photographs in newspaper at the instance of the bank, and it will remain a permanent taboo for their family. The publishing of the photographs in newspaper for their inability to clear the loan arrears to the bank in time is clearly an affront to the right to live with dignity and the honor, as well as the right to privacy of the loanees. I have no hesitation to hold that publishing the photographs of by the bank under such circumstances is violative of the right guaranteed to the loanees under Article 21 of the Constitution of India. Paragraph number 11. The above clause in the agreement at the best impose the bank to reveal the name of the loanees in the print media or disclose the information and data relating to the credit facility to the credit information companies. The loan agreement nowhere enable the bank to publish the photographs of the loanees in newspaper on their failure to repay the debt within the specified date in threaten. The loanees are also not stopped from challenging the action of the bank in publishing their photographs in their newspaper, even if there is such permissive clause in the loan agreement. This is because estoppel is not defense available to the bank when its action is challenged on the ground of violation of the fundamental right of the loanees. A reference in the context of the dictum laid down by the full bench of this court, Dr. Saurabh Jain versus State of Kerala. My lord, next judgment, my lord. Managing committee of Agricultural Cooperative Society versus Assistant Registrar of Cooperative Societies.
Which is the paragraph?
My lord, paragraph number 6 and 8. The next judgment, my lord, start from page number 10. In the case of my lord, Punjab National Bank, paragraph number 6 and my lord, in page number 18.
Please read.
Please, my lord. Page number 10. In the my lord, page number 10, I mean, my lord, writ petition number 862, paragraph number 26 of the judgment. My lord.
No, there is in between, there is another judgment. 2024 SEC Online Kerala.
Please, my lord. In that, my lord, it starts from my lord, page number 7. I'm relying, my lord, paragraph number 6.
Yes. Next.
6, my lord, it says the Kerala Cooperative Society.
I've seen that.
My lord, in next judgment, my lord, Missile Export Private Limited versus Punjab National Bank. It starts from page number 10. I am relying, my lord, paragraph number 26. The first point is thus answered by holding that statute does not conceive conferring power and securitator or its authorized officer to publish the demand notice in a newspaper without having reason to believe that such publication is imperative, having regard to the facts that circumstances before, and that at such stage there is no question of reading power of publication of photographs in this newspaper along with the demand notice. My lord, next judgment which I am relying, my lord, Ujjwal Kumar Das versus my lord.
No. What is the submission on paragraph number 26?
My lord, in this case also, my lord, in a similar set of facts, my lord, they published.
No. As it is, a plain reading of paragraph 26, what is that the court is saying in this?
My lord, publication of photographs is, my lord, not permissible.
No, read it again.
My lord, the first point is thus answered by holding the statute does not conceive conferring power on a securitator, its authorized officer, to publish demand notice in newspaper without having reason to believe that such public. My lord, I'll just
what
read,
does it mean?
My lord,
Again,
next paragraph
there-
I'll just read, my lord.
There are
Paragraph-
valid reasons it can be done.
My lord, just 29, I'll just read, my lord. It is settled, 29. It is settled law that if the statutes require particular act, thing to be performed, done in particular manner, it has to be performed, done in that manner alone or not at all. The bench need to be burden judgment with the authorities on the points suffice to record. It demand notice under section 13(2) of the act is served on the borrower, guarantor in the manner statutory provided by. There is no reason all to believe the service has not been affected. Question of publication thereof newspaper does not and cannot arise. It is only when the opinion could reasonably be formed that borrower is awaiting the service of the demand notice and that alternative mode service have been exhausted without seemingly positive result in view of thereby making imperative to proceed with the last option, publication of newspaper, that recourse that could be taken, the requirements of formation of opinion which must be available in the record is that sine qua non and the law cannot be observed in this beat.
Yes.
My lord, next judgment, my lord, which I'm relying.
Paragraph.
My lord, it starts from page number 21. Ujjwal Kumar Das versus State Bank of India.
Yes.
Paragraph number 24. My lord, I'll read, my lord, last 1, 2, 3. 8th line, my lord. Section 17. Section 17 of Surface Act could be approached. The quite some time thereafter, the tribunal under section 3 of section 17 holds that the securiticator and acted contrary to the other provisions thereof while enforcing the security interest under subsection 4, section 13, and ultimately direct the restoration of possession. The damages that could be caused to the reputation of the dignity of an honest borrower, guarantor by reason of publication of these photographs in the interim would be irretrievable. It may not be possible to compensate such damage by money. A borrower guarantor who has been proceeded against the contrary of law by securiticator and whose photographs is published is unable to bear the dignity and takes the drastic step. Since the publication of photographs have been defaulting, the borrower guarantor has the potential and exposing him to irreparable loss, injury, and prejudice. Publication of photographs cannot be resorted to the absence of an express power or an agreed terms in this behalf. My lord, paragraph 29 also, my lord. Adverting the letter issued to Reserve Bank of India appears that the decision of the so and so duty notice considered necessary to reproduce the letter dated so and so. My lord, here also, my lord, the Honorable High Court of Delhi.
Yes.
My lord, the next judgment which I am relying, my lord, from page number 30.
Paragraph.
My lord, it talks about, my lord, Article 21.
Paragraph.
I'll just give a note on these two judgments, my lord. Lord, my respectful submission before this honorable court. No doubt, my lord, I have gone, my lord, according to me, my lord, in this sale notice, my lord, we have, my lord, sale not taken place. Subsequently, one more sale taken place, my lord, I have approached before the DRT. Before this also, I approached the DRT. It's a matter of fact. And earlier rounds of it. In this case, my lord, my specific condition before this honorable court, they are, my lord, they are not to publish they don't have a right to publish my photographs. My property worth is, my lord, much more than their value of the, my lord, loan. At the most, my lord, they would have issued demand notice, sale notice, and they would have sold the property. Therefore, my lord, I am
File your objections to this writ petition. You're not audible.
Yes, sir.
Milords, let my learned friend survey a copy of case laws. We'll file my objections. I have a 2-3 case laws where it's covered by division bench judgment of Honorable High Court of Calcutta, Milords, that such publications can be done. I'll place it before your lordships.
When a writ petition is filed in the month of February, why are you waiting without filing the objections? Then that means you don't want to file the objections. I will consider that way and pass the order.
Milords, this is the first time it has come after 7/2/2025. First time it has come before this court, Milords.
Now, when a writ petition is filed, once you enter your appearance, there is a limitation for filing objections, is it not?
Absolutely, Milords. We'll file our objections, detailed objections. Maybe matter taken up next week, Milords.
For the petitioner, no objections are filed with the respondents. Finally, list this matter on 18th. By that time, if the objections are not on record, taking that, the objections as nil, the orders will be passed. Yes.
But the case law said,
My-
case laws may be, copy of case law may be
I'll supply
provided.
today. I'll
Yes,
supply
sir.
today.
Shri Rajshekar.
There's no interim order, my lords. Can I argue this matter on Tuesday, Monday or Tuesday, my lords? There's no interim order.
Problem is, there are so many matters every day
I
coming
understand, my
up.
lords. I
Keep
owe an
on,
apology to the court because at my instance, I'm taking adjournments in many of the
This is
matters.
matter on 25th of November.
Lordships.
Yes.
10.
My lords, I
Rachana?
appear for the petitioner, my lords.
Yes.
My lords, in similar matters, my lords, interim order has been passed by this honorable court, my lords. If your lordships may refer to page number 249, my lords, Annexure P, my lords.
No, we will hear the matter. Interim orders are not
My
binding
lords,
on the.
in the meantime, my lords, let there be no precipitative action against them.
First of all, I have to convince myself whether it's a case for interim order or not.
Yes, my
Without
lords.
that, why would I direct them?
Yes.
Where is the impugned order?
My lords, page number 249, my lords.
200. Let's look at the prayer first.
Yes, my lords. My lords, my prayer is at page number 30, my lords. My lords, this is a writ of mandamus, my lords. Issue a writ of mandamus or direction to restrain the respondent number 5 from initiating or continuing any sort of precipitative action, including
First,
but not limited.
Prayer number 1.
Prayer
Can
number
this-
1, my
Can this
lords.
court grant such a prayer?
My lords.
No.
My
Then
lords.
please read the next one.
Direct the respondent number 5 to cease and desist from recovering EMIs, my lords. My lords, the petitioner has been paying the EMIs, my lord. My lords, what has happened in this matter is that the bank and the builder.
I understand what are all these release you are seeking? How did you file a writ petition of this nature? No impugned order, nothing. You just say.
It is only a writ seeking directions, my lords.
Why will the court grant direction?
My lords.
What are the other writ petitions?
My lords, they are of similar in nature, my lords. Wherein
I will post all that and I'll dismiss. What is this? Can the High Court pass? High Court has to direct the respondent number 5, that to a mandamus, initiating, continuing any sort of precipitative action, including but not limited to any civil or criminal proceedings, in order to recover the purported loan outstanding against the petitioner, number 1. Directing respondent number 5 to cease and desist from recovering EMI payments in respect of the loan accounts from the petitioner. Issue a writ of mandamus in the form of directing respondent number 5 to recover from respondent number 6 the EMI payments along with penalty accrued with respect to loan account.
My lords, what has happened is that
whatever has happened, what is the role of this court in these kind of things?
My lords, at least till next date of hearing, no precipitative action will be taken.
First of all, I'm saying writ petition is not maintainable. Question of next date will not arise. I'm going to discuss it right now.
My lords, there are similar matter pending before the apex court also, my lords.
Let apex court decide. I will
It has
not
been-
interfere.
My
You
lords.
take this matter also to the apex court. Now I'll pass an order.
My lords.
This is heights of interference. The kind of interference you're seeking from my court.
My lords, it's a humble.
Is it a legally tenable ground? Not even one.
It is a humble request. My lords.
No humble request for.
My lords, some time may be granted,
no,
my
no,
lords.
no.
I'll convince this court, my lords.
No,
my
no,
lords, any other date, my lords.
Why
I'll
should all the
convince.
matters be listed before the court? Because these matters are listed, I'm not taking up other matters.
My
You
lords.
only moved the memo.
Yes, my lords. My lords, any date, my lords.
List this matter.
I have one submission matter. I am appealing for Union of India in this matter. The coordinate bench has dismissed the similar petition. my lord.
Anybody will dismiss. For that, an order is not required. List this matter on 10th. No further adjournments. The causes should reflect it. Yes.
Number 11.
My lord, in
11.
state number 11, my lord, I appeal for the respondent 5, my lord.
11.
My lord,
I'm
this is
seeking.
similar matter to the previous matter, my lord.
Huh?
My lord, this is
Similar
similar matter, my lord, to serial number 10, my lord. Where, my
List
lord,
this matter also on,
it's the same, my lord.
on 10th.
My lord, could it be
No
connected?
adjournment to be granted. Yes, 12.
My lord, may I
Number
make
12,
one
Vinod
submission?
Prasad.
My lord, there
Yes.
are 12 other writ petitions, my lord, of similar nature.
Please,
I have numbers, my lord, I'll
court
give it to the
officers,
court officer.
all numbers I will list on the same day.
Please, my lord.
Court
I'll
officer,
give it to the
take
court
those
officer.
I'm
numbers.
appearing for
All
serial
matters.
number.
Please, my lord. I'm obliged. my lord.
Yes. 12.
I'm appearing for
I
serial
appeal
number
for that.
11. I'm seeking a short adjournment in this matter, Your Lordship. Senior is in personal difficulties.
It's posted to 10th. You come on the day. Yes.
Well, this question of law requires some more reading. I may request to take on Monday because whatever citation he has given, it was from DRT 213.2. It is not civil court. Now already after issuing notice,
According to you, in respect of securitization matters, more than DRT, the civil court will have a
what I say, my lord, in that case, it was DRT 213.2 and 4.
Yes.
Here it is, they take issued notice, then they have filed civil court, then they have issued 13.2, now they have taken action.
That will not have a bearing. How they
What I
have
say is whether
is it that redemption of mortgage thing?
No, no, it's not. so,
What
my
is
lord.
this?
Whether I filed a suit for, my lord, money recovery suit before the civil court.
Hmm.
And my lord, in addition to that, my
Oh,
lord, I
whether
did-
simultaneously you can,
That's what transfer provision.
as per the, which provision?
My lord, in the judgment, my lord, passed by the Honorable Apex Court in the transfer, it says that, my lord, in addition to, my lord, recovery, my lord, actions which I can file before the
With
DRT,
reference to any of the provision of the Surface Act?
it is not, my lord, it is, in this case, my lord, in the paragraph number 63, it says that it is one addition, my lord, enactment for the bank to recover its money.
Apart from the civil suit.
Apart from the civil suit, recovery.
my lord, there is doctrine of election, if they have elected, go to civil court. Then my grievance is, it is the prime chief
Anyhow, you want time, I will grant time.
till
I'll
Monday or
take up-
Tuesday,
I'll take up this matter on 11th.
till Monday or Tuesday.
No further time.
How much time?
List this matter on 11th, no further time. Yes, 13.
13, Mahesh
Petitioner,
Chaudhary.
Your Lordship, it's a fresh matter coming up
Yes.
for the first time, Your Lordship. I have challenged the order passed by
Who are the respondents?
Please, Your Lordship.
Who are the respondents?
Your Lordship, respondent is the Finance Bank Limited, Your Lordship.
Whoever it is, take out hand summons.
Please, Your Lordship. Your Lordship.
Counsel for the petition is permitted to take out hand summons.
Your
On
Lordship.
the council, notice to the respondent.
Your Lordship,
This matter, once a notice, hand summons, oblique notice is served. Yes.
One request, okay, Lord. Okay, may I be permitted to move the matter, Your Lordship? The only thing is they have taken the possession of my house, Your Lordship.
It will be listed the moment you file a hand.
Please,
If it is not, I'll give a memo.
Please, Your Lordship.
Yes.
14, Bharat Kumar.
Petition. Senior is not well. Next Wednesday, date may be.
That was the respondent, my lord.
12th only.
A short date may be given, my lord.
12th only.
2.5 crores has been deposited by the bank. It is lying in the bank, my lord. Matter has already been disposed. Only thing is this amount has to go to whom? That is our matter. That honorable division bench has already decided the matter, my lord. A short date may be given, my lord.
Interim order is continuing from when? 29/2024. What is the outstanding amount?
No, my lord, this matter, my lord, this matter was ultimately referred to the division bench, my lord. The honorable division bench remanded the matter to DRT to find out whether the sale has been taken place in accordance with the provisions of the Surface Act. Then again, that the learned DRT, after making inquiries and hearing the arguments, passed the order that the bank has sold the property in terms of the all provisions
So
of the Surface
sale
Act.
is valid.
Valid. Now, my lord, then I filed an application because during the pendency of that writ petition before this honorable division bench, the honorable division bench directed the bank to deposit about 1 crore 43 lakhs, accordingly deposited. Then I filed an application stating that since the matter is already over by DRT, to return the money. Then immediately that writ petition was filed. No, there is something that is there. Then this honorable court says that that sale regarding execution of the sale and all these things, his contention is, my lord, that property has been sold, possession has been handed over, and he is in possession of the property for last so many years. Now he says, no, I want my money back with interest. That honorable court said that learned division bench said, no, it is not possible. In fact, my Supreme Court also, honorable Supreme Court says, once the property is sold and sale certificate is issued and it is registered, then it cannot be first unless there is irregularities in the conducting auction or there is a fraud element is involved, except that
What is the interim order in this?
interim order not to precipitate till this writ petition is over. That's all. But the amount has to be now, that has to be decided.
Lisa matter on 11th.
12th, not
Huh?
12th.
12th, no further adjournment.
Interim order may be extended.
Interim order earlier granted is extended till.
Much of it.
Yes.
My lord, opinion for me.
Manjuna?
Petitioner has avoided loan from the respondent bank, my lord. Was directed to continue to pay the installments accordingly regularized. And I was continuously paying the installments. And during month of February 2025, my lord, on the basis of the order passed in the year 2023, my lord, they evicted me, my lord. Thereafter, my lord, matter was listed before the Sam court, my lord. When I produced the statement of accounts, my lord, the honorable court, my lord, directed the respondent bank to look into the matter, my lord. Today, they have sent a text message calling upon me to pay a sum of rupees 1,44,292 to not to, I may permit.
Take that.
Therefore, I am praying 15 days time to pay this amount and to direct them to restore possession.
From the date.
It is an SMS, sir.
Please, ma'am.
My lord, from the date of taking physical
Today
possession
at
of the
12:45
property,
PM it is.
I deputed the security personnel for
one minute,
which 30,000 is the amount I am incurring.
1 minute, what
Where-
is the order that is?
Section 14 order
Your
challenge.
lordship can attend to the statement of account produced by me, wherein they have.
1 minute. 4/1/2023.
Yes.
Order that is passed for the magistrate is in question before the court. Huh?
My lord,
The order passed for the magistrate dated 4/1/2023 is in question before the court.
yes, my lord.
What is the outstanding amount?
Outstanding as on today, 12,61,086 rupees is the outstanding, my lord. In fact, they undertaken to close the entire dues. From the date of taking physical possession, 30,000 rupees is the amount I am spending per security personnel. Wherein the EMI amount is around 8,000.
You're taken possession.
Yes, my lord.
They have taken possession in the month of February 2025 on the basis of the order passed in the year 2023. Your lordship, I have kindly, I have produced the statement of account wherein they have regularized and permitted the petitioner to pay the installments regularly. It has been regularized, madam. Your lordship, can you turn to the statement of account produced by
File your
me?
objections to this.
Petition copy itself is not.
Give this copy, serve on him. Counsel for the petitions to serve the copy of the appeal.
The
petition.
last
Madam,
payment
one
made
submission,
on
madam.
September. Before that, they are not regular in repaying
Madam,
them,
one submission, madam.
EMIs, my lord.
There is no interim order in this.
Yes, my lord.
So please file your objections. He is saying that you have already regularized. Once having regularized, again, you cannot say that it is declared as NPA earlier.
My
That's
lord,
what is his
now I
contention.
came to know, my lord, they have
Not
issued
true.
paper publication for public auctioning of the property matter, but no notice has been given to me. It is.
If notice is given, then you come.
No, my lord, because I am not in this, since they are dispossessed. I am residing in the slum. It is a slum.
But I'll not grant any interim order at this stage without understanding
My
what
lord,
is the factual aspect.
Factual aspects.
Whatever you say that I
My
cannot
lord,
take it
I
as
am
a.
not stating beyond this thing, my lord. I have produced the statement of accounts, which was issued by the respondent bank
Get
itself.
instructions.
Yes, my lord.
My-
Petition
Keep a copy.
copy.
Please,
No.
my lord.
Yeah, this is
One-
matter.
One submission, my lord, because I have filed NOC, my lord. The advocate, my lord, who has given NOC, he has not returned the file itself, my lord. Therefore, my lord, I am permitted to take this.
Without a file, you want an interim order.
My lord, that was.
This
I
is
don't-
matter.
Monday, my lord. Monday or Tuesday, my lord.
On 11th of
Kindly have it
November.
on 10th, my lord.
Huh?
10th.
10th of November, by the time the petitioner, the petitioner shall serve the copy of the writ petition on the council by 7th of November. By the next date of hearing, counsel for the respondent shall get instructions. Yes, 16.
My lord,
16.
my lord, one submission, my lord.
I will not grant interim order, Mr. Counsel. Yes.
Leeladhar.
I appeal for the respondent.
Appearing for the respondent. Petitioner. Your Lordship, see that outstanding
instructions?
amount is
Yes, my lords.
outstanding amount, your worship, is internal page number 14. The outstanding amount on 4/3/2024, according to them, is 94
Yesterday you were
lakh.
saying that you will pay the entire amount within 1
Yes,
day.
your worship.
My lords,
Even I made
earlier
the-
writ petition is filed, my lords, seeking the same prayer, quashing of possession notice, my lords. They themselves withdrew the petition undertaking to pay the full amount, and this honorable
When
court.
was that undertaking?
My lords, 12/12/2024, my lords.
Where is that?
Uh,
In this case?
Yes, no, my lords, it was in the previous writ petition challenging.
Is it filed before this court?
Yes, my lords,
I have produced
challenging,
also.
challenging the same possession notice. It is withdrawn, saying I'll pay the entire amount, and this honorable court takes that.
Where is that order?
Please, my lords.
Internal page 31, your worship.
Page number 33, my lords, in fact.
And the order
The
is
petition.
33, your.
The writ petition is filed
House.
questioning the possession notice.
Please, my lords. This writ petition is also filed questioning the
How
possession
can you
notice.
file a writ petition?
My lords, I've taken that objection in my statement of objections. And prayer two is, my lords, the
Petitioner challenges
direction for me.
So and so. Directed both the parties so and so. Therefore, it is expedient to dispose of this petition, reserving liberty to the petitioner to approach the respondent bank to close the loan amount, and upon depositing of the entire amount, the respondent bank shall close the loan account and release all the original title deeds in relation to the subject property.
Yes.
This order.
My lords,
Yes.
after this, if I may, my
Thereafter,
lords,
your order.
just take a minute. After this order, my lords, in March 2025, the petitioner addresses a notice to me saying, I'm ready to pay the outstanding amount as is reflecting in the possession notice, you are not ready to take. My lords, obviously the bank's response is that you have to pay the outstanding amount as on date, not with the amount which is reflecting in the possession notice, because my lords, the possession notice is.
Yes, understood.
Yes, my lords. My lords, after this petition came to be filed also,
So
my
all,
lords.
how this writ petition is maintainable?
My submission, your worship. I am ready to deposit the amount.
Forget about you're ready to deposit. You are
When
you
they
are
have,
already ready.
when they have.
How this writ petition is
Hello,
maintainable?
when they have refused to receive the amount, your worship, they have no other
File a
go.
contempt.
Pardon?
File a contempt.
My submission, your worship.
This
Your
kind of
worship,
writ
your
petitions we
worship,
cannot
in
entertain.
page number 34, your worship, turn it, your worship.
I've
Please,
seen-
please,
I've
please,
seen
in
the
page number
order.
34. I issued a notice. I come for your branch every time. Please take the amount and discharge my record as per the direction of the
They don't
honorable
want
court.
money, that's why they are not taking, right from
So
December
as
2024.
per the direction of the honorable court, your worship, I approach the bank. They have not received, they want only money. They want only interest to be. They should not want to clear the amount. They wanted to get interest.